And do we have water? All right. All right, back on the record in the Simpson matter. Mr. Simpson is again present before the court with his counsel, Mr. Shapiro, Mr. Cochran, Mr. Bailey, Mr. Douglas, people represented by Mr. Kelberg and Mr. Lynch. Jury is not present. Counsel, anything we need to discuss before we invite the jurors to join us? All right, Deputy McNair, let's have the jurors, please. Did you see Judge Baskew's memo of June 13th regarding weapons screening on the 9th floor? All attorneys are going to be subject to that. All right, let the record reflect that we've been rejoined by all the members of our jury panel. Good morning, ladies and gentlemen. All right, Dr. Lakshmanan is again on the witness stand undergoing cross-examination by Mr. Shapiro. Mr. Shapiro.
Morning, Mr. Kelberg. Morning. Good morning, Your Honor.
Morning, Mr. Shapiro.
Good morning, ladies and gentlemen. Good morning once again, Dr. Lakshmanan.
Good morning.
Dr. Lakshmanan, it's clear from your testimony that you were not present when these murders took place.
That is correct.
There were no eyewitnesses to these murders.
That is my understanding.
There has been no weapon that has been associated with these murders that's been recovered.
That is my understanding.
So clearly, what you are here to give us when you tell us that in response to hypotheticals from Mr. Kelberg as to how you are trying to reconstruct what might have happened, when you say it could have been or could be, you are speculating.
I won't say it's speculation. Based on the hypothetical, I saw whether the medical findings, which I have had an opportunity to review, fits the hypothetical, because sometimes the hypotheticals which are given may not fit the medical findings I have, and then I'll say it's not consistent. So the hypotheticals which were presented during the direct examination fitted some of the medical findings, and that's why I said it's consistent. So it depends on what the hypothetical is.
When you use the term could be, is that a term of medical certainty?
Could be is not medical certainty, but it's based on education and the findings that it's a good possibility that's what could have happened.
Could be is a possibility.
That's correct.
And when you say something could be, fair additional response would also be it could have been something else.
No, because as I mentioned earlier, there are some wounds on both the bodies which are clearly a single-edged knife, and I have opined that. There are other wounds on the bodies which could have been a single-edged or a double-edged knife. So there's a little difference. So when the question is posed, can all the wounds be by a single-edged knife? I'll say could have been, because there are some wounds on the bodies which could have been single-edged or a double-edged, but there are wounds which are only which could be caused by a single-edged knife from my review and the report.
When you talk about the relative positions of the parties, let's get away for a minute from single versus double edge. I think we've covered that in a great amount of detail. When you give an answer as to the positions of the assailant or assailants and victim, and you answered could be, you were not giving us any medical certainty, were you?
No, but the answer was pertaining to that hypothetical, the injuries on the body match the hypothetical.
How many different scenarios do you think one could reasonably come up with as to the positions of the bodies at the time of death between Nicole Simpson and her assailant or assailants?
You mean the, could you repeat the question? I didn't catch the earlier part, I'm sorry.
How many different reasonable hypotheticals could you come up with regarding the relative positions of Nicole Brown Simpson and her assailant or assailants?
For the final wound, there's only one possible position. I already opined that. But for the other wounds, there could be several other scenarios. But I would rather you give me a scenario and I can opine whether that scenario would fit the injuries I have reviewed.
It's your testimony that you are medically certain the position of Nicole Brown Simpson and the position of the assailant at the time of death, or assailants.
Not on all the wounds.
On the fatal wound, are you medically certain as to the position of Nicole Brown Simpson at the time she received the fatal wound?
Objection, Your Honor. That misstates the testimony as the number of fatal wounds.
Sustained.
As
You're
to,
referring to one specific.
yes, as to the last fatal wound, are you medically certain as to the position Nicole Brown Simpson was in at the time she received that?
Yes.
There are no other reasonable interpretations that other experts could give.
I've given you my opinion.
Are there other reasonable interpretations, other experts that you would hold in high regard could give?
I would like to listen to them before I offer any opinion, whether I agree or disagree. But I have clearly enunciated, I think, during the direct examination, what are the reasons why I felt that that particular wound took place in that particular position. And based on the crime scene photographs and the medical findings. So I do not know what other opinions are being offered. And when I hear them, I can then make a decision.
Are you certain as to whether the assailant or as to whether there was one or more assailants regarding Nicole Brown Simpson?
I'm not certain.
Are you certain as to whether the assailant or assailants were right or left-handed?
I've already opined on that, I think.
I'm asking you, are you certain?
I'm not certain.
And again, that's because you weren't there and there are no eyewitnesses to this. Isn't that correct?
That is correct, but what I gave was what are the possibilities, and based on the wound. For example, the last wound on Nicole Brown Simpson had to be a right-hand person because the wound traverses, in my opinion, from left to right. And it has to be done from the back based on the blood flow pattern.
Isn't that equally consistent with, how many different ways can a right-handed person hold a knife?
They could hold it in different ways.
How many different ways, in your opinion as an expert, can a right-handed person hold a knife?
I already showed one way they could hold it. They could be the, but for that wound, it had to be held in that way.
No, that's not my question, doctor. How many ways, as an expert, can you tell us that a right-handed person can hold a knife?
Only, there's only one way you can hold the knife. Hold it in the handle part. I mean, how else can you hold it?
Your testimony as an expert witness is a right-handed person can only hold a knife in one position.
Well, I mean, for the wound which was caused.
I'm asking you, how many, this is a broad question.
Okay.
Okay. question is, and I think it's pretty simple.
Objection, Your Honor, counsel statement.
Sustained.
How many ways can a right-handed person hold a knife?
It's only one way I can see a person can hold a knife if you're going to hold it in the handle part.
Only one way. And how many ways can a left hand?
For the record, the doctor with his right hand, he reached out and appeared to twist his wrist as if holding an object.
Yes.
How many
If you
ways?
give me a knife, I can show you what are the ways you can do it. That'll be
Well, have
better
you-
to do it because this way we can demonstrate it better because instead of going over a hypothetical in an abstract sense, if you give me a knife, let's go over it and I'll tell you how are the ways you can hold it. And we can look at it and make a decision on it.
Your Honor, I would object to the witness asking questions.
That was an answer. Ask your next question.
Can you tell us how many ways a right-handed person can hold a knife as an expert?
I think the best way is to demonstrate it.
So the answer, would you give us an answer or you cannot tell us?
I can tell you if you have the knife, if you can give it to me in a weapon, and I can show you what are the ways I think it can be held. But to make it useful as an object, you can hold it in certain ways. But in certain other positions, it won't be useful as to the function of that weapon.
So I understand you, and I don't want to belabor this point. You can't articulate how many ways a right-handed person can hold a knife?
I think for somebody to understand, it'll be difficult unless you give a demonstration. In certain types of situations, that's the best way to do it.
Well, let's assume we have reasonably intelligent people listening. Can you verbalize how many ways a right-handed person can hold a knife? If you can't, just say you can't.
I said I could, but I said it'll be better to demonstrate it.
Okay, you can. What is the answer? How many ways can a right-handed
You could hold
person
it with the
a knife?
blunt edge facing you, the sharp edge facing you, depending on where you hold the handle. There are only two parts to the knife. There's blade and that handle, and you're going to hold it in the handle portion. And either if it's a single edge knife, the one sharp edge is going to face you when you hold it in one manner. If you rotate the knife, the blunt edge is going to face you. And hopefully you won't hold it in the blade portion, so then it won't serve the function. And if it's a double-edged knife, it doesn't matter how you hold it because both edges are available for causing the function you want it to perform.
So your answer is for a single-edged knife, you can hold it in two positions.
Yes,
And for a double-edged knife, you can hold it in one position.
yes,
For a right-handed person.
yes,
Would your answer be the same for a left-handed person?
yes.
Can people hold knives in different angles?
Very good.
Would there be an infinite number of angles that somebody could hold a knife?
Yes,
For example, a right-handed person could hold a knife backhanded and make a thrust with the blunt edge out. Is that correct?
yes,
And a right-handed person could hold a knife with the blunt edge out and make a thrusting motion from the right side. Is that correct?
you're using an example of a single-edged knife, I presume.
Yes. Is that correct?
Where's the blade portion in your hand right now? You made a fist, and I want to know which.
Let's.
Excuse me. My evidence collection.
Thank you, Judge. I knew you would always have some demonstrative evidence.
Gilbert, did you mark those knives that you had?
I think we did, Your Honor. And we only needed them that first day, so they were kept downstairs, as I understand it.
All right.
Okay, at the moment, I think I can give you an exhibit number.
All right, doctor, this is a single-edge knife.
I have not looked at it in close. Yes, it looks like a single-edge knife.
So, one way a person could hold the knife would be with the forearm back and the blunt edge to the outside. Is that correct?
If the thrust is being made in the fashion you're demonstrating and a wound is inflicted, it's a possibility, yes.
Then the knife could be turned just the opposite way and a thrust could be made.
That is also a possibility.
That would cause a blunt edge to the inside and a straight edge to the outside.
Depending on which part of the body it's striking.
Mr.
Now-
Shapiro, would you just turn slightly? The jurors in the back end were looking to see how you were holding the knife. All right, thank you.
This was the first time. This was the second time. Now, on the wounds that you saw on Mr. Goldman's neck, you saw one wound with a blunt end in one direction and one with a blunt end in an opposite direction.
In Goldman's wounds, both were incise slash stab wounds, which I described. So it could have been either way.
And the same would be true if somebody held a knife coming from the outside of the right hand. They could thrust it with the blunt edge out, or they could thrust it with the blunt edge in.
That's correct.
Could also somebody take a knife and thrust it underhand?
They could do that also.
And there would also be 4 possibilities of doing it that way, wouldn't there?
Yes.
Turning the knife the other way and also coming backhand, straight in.
Excuse me, Mr. Shapiro. You're getting a little too close, if you don't mind.
And also, somebody could come from the bottom, is that correct?
That is also a possibility.
And that would be 4 additional ways.
That is correct.
And then a right-handed person could also from behind come backhand the same way we've described. Isn't that correct?
That's also a possibility.
And from behind could come forehand.
That's what I demonstrated in my demonstration, yes.
And the same thing for a left-handed person. A left-handed person could come behind
Yes.
on either side.
Yes.
So you couldn't tell whether it's right or left-handed because there are so many different ways a knife can be held. Isn't that correct, sir?
I thought I opined that
And you really can't tell positions of the body because there are so many different, there are an infinite number of ways a knife can be wielded. Isn't that correct?
we have discussed that, yes.
You told us yesterday that there was a technician by the name of Mr. Taylor who was present at the autopsy of Mr. Goldman and Miss Brown Simpson.
Yes.
And that Dr. Golden was present.
Yes.
Was anyone else present at the autopsy?
Yes, he was also, I think, assisted by Miss Maria Diaz.
Maria Diaz?
Yes.
What was her role?
I mean, technicians assist in the autopsy, as I told you, help in removal of the organs and assist the doctor in any way they need to assist the doctor. So, and I already told yesterday, I was not there when the autopsy was being performed in its entirety, so I don't know what exact assistance was provided to Dr. Golden by these 2 technicians. But I do know that Mr. Taylor took the photographs because some of the photographs which were on display on the poster board was the photographs taken during autopsy, especially the photographs of the scalp wounds on the victims.
Is Mr. Taylor a competent technician?
Yes, he is.
Is he somebody whose opinion you rely on?
On Mr. Taylor?
Yes.
I worked with him for many years. He's been there in the department many years, so I know his competence.
Is he
I don't
honest?
have to get opinion from others on that.
In your opinion, is he honest?
In my opinion, he's always been honest to me, and he's done his job when I asked him to do something.
Anyone else present that you are aware of during the autopsy of both of the decedents, or either of the decedents, I should say?
The autopsy supervisor and the other autopsy technicians will also be present. As I told you, there are totally 6 stations in that room, so there could be other doctors and other technicians there in that room at that time, so I can't really tell you who all were there. I already said that yesterday.
Are there any notes or logs to reflect who was there?
I could try and obtain some information for you on that because who were working that day, but I can't really specifically tell you who was in the autopsy room at that time because, as you know, we do certain number of cases a day, and different doctors could be doing different cases at that time, and during the span these cases were done, and technicians could be taking breaks, other technicians could be coming in. So really all I can give you is who was working that day and what cases were done, but I really can't tell you with certainty who was there in the room when these cases were being done other than what I've already told you.
Are you saying you do not keep log records of who is present during an autopsy?
We do. We usually keep log of the witnesses who attend the autopsy, and there is a log of which technician helped with a particular case. But I thought your question was who all were present in that room, so that's what I was trying to answer.
No.
But I already told you who helped Dr. Golden on these cases.
Let me be more specific. With regarding Nicole Brown Simpson, do you have log records of every person who was present during the time her body was autopsied?
I have to check the autopsy technician sheet, which they do maintain who helped whom, because that was one of the procedures which should be in place.
My question wasn't who was present. My question was, do you have records as to who was present?
I said I have to go and check into that. I don't know whether they have the records or not on that particular issue.
Are you supposed to have records of who was present at an autopsy?
It's kept that we have the record of the technicians present because the same technician may help in other cases, so we will have records on that.
Are you supposed to keep records of everyone who is present at an autopsy? Yes or no?
We only record the witnesses present during the autopsy, not the technicians.
So you will have records of the doctor who was present and the witnesses, but other parties, you will not have records.
I didn't say that. I said there are technicians who helped in the autopsy. We keep records of the technicians' roster there. And I already told you who the technicians helped in these cases, but I'm not sure whether we have information that these are the only technicians who worked only on these cases, or did they do other cases? That's what I'm saying.
By policy, would you kindly tell the ladies and gentlemen of the jury what records should be kept of who viewed the autopsy of Nicole Brown Simpson?
The persons who view the autopsies would be the doctor, the technicians who assist the case, and the witnesses would be the police officers who attend the autopsy. And of course, other doctors and technicians who are in the autopsy room will be seeing portions of the autopsy.
Well, those are the records you should have.
Yes.
Do you know if you have such records?
I said that I have to go and check in my department to see whether we got the log sheet for that, and I'll be happy to provide that. And I'm sure we do.
So the question is, you expect that you do, but you don't know.
At this time, I don't have it, so I have to say I don't know, but I'm sure it will be there to get you that information.
Do you have any information as to whether or not any police officers were present during the autopsy?
Yes, I already showed that on the Form 15. Dr. Golden has clearly recorded Detective Van Atten and Lang to be present during the autopsy on the Form 15. It says witnesses to the autopsy. We saw that yesterday.
Was Detective Furman present during the autopsy?
As I told you, that is not recorded, so I would have to presume that he was not there.
Do you know that for a fact?
I told you I reviewed the records and I gave you the information for the records. I was not present during the whole autopsy.
Is it important to maintain the security of the area where an autopsy is taking place?
Yes, and the security is provided for the department to have only people who are responsible to be there.
Well, isn't it true that construction workers were in the proximity of Mr. Goldman's body?
Your Honor, all objectives vague on the term proximity.
Sustained. Phrase question.
Do you know what close to is?
Close to means ability to observe a process.
Do you know whether or not construction workers were close to Mr. Goldman while he was in the coroner's office?
I'm not aware of that.
You hadn't heard that from anyone?
No.
That wasn't brought up in any of your meetings?
No.
Would you be surprised if that happened?
Well, it'll be a new information which I've learned from you.
Would you be surprised if that happened?
Well, I won't be surprised because there are people who visit the department and who are also, there may be repairs going on, but I'm not aware of it, that a construction worker was there watching the autopsy.
Would there be anything wrong with that?
Well, I don't know whether it's wrong or right, but if he observed it because he was doing some construction work. So I can't say it's right or wrong, but I would prefer that it was not watched because it's a medical process and only the doctors and the technicians and the detectives who are supposed to be present should be present.
Was Mr. Goldman's body, from the time it was brought in, ever left unattended, to your knowledge?
As I told you, when they are left in the crypt area, they are left unattended because the doors are closed and they are unattended at that point. So I do not know what you mean by unattended.
Left out in view of people other than medical professionals necessary to do the work of the coroner's office?
As I told you, I've given you the whole process on last Tuesday, how the bodies went through our office and where they are stored. So it's my understanding that only the people who work in the department and who should have been watching the process, because that's my understanding.
What about is there any hallway areas where bodies are left prior to autopsy or after autopsy?
If at all they are left, it's for a short time because you have to move a body to place another body in the autopsy room. So for a short period, they will be in the hallways because you have to go through the hallway from the cold crypt area to go to the autopsy room. And I didn't have any photographs of the hallway, but there is a transit period. And also, so to answer your question, there is the bodies will be in the hallway at some time between the crypt and the autopsy area.
Was Mr. Goldman's body ever left in the hallway unattended?
Not to my knowledge.
Would that be a violation of your policy if it was?
I won't say it's a violation because they would usually try and place the bodies as soon as the autopsy is done back in the cold crypt area. But as I told you, I'm not aware that was done. So it's we like to remove the remains from the autopsy area and put them in the cold crypt area as soon as possible because it's good to preserve the bodies in the cold area as much as possible, depending on the situation that day.
Would it be proper for construction workers to be close to Mr. Goldman's body while it was in the hallway?
I said I'm not aware of that, so.
I'm asking you if it happened, would that be appropriate?
Well, if the person was there in the hallway doing some kind of construction work or he had to do some repairs, that's something which we can't avoid as long as he doesn't touch the body because the bodies are kept on gurneys.
How would you know if he touched the body or not if nobody was watching?
Well, as I told you, it's beyond my expertise to tell you what exactly happened, but I'm telling you that it should not happen, and it's my understanding nothing of such nature happened.
Now, you have told us that all of your information regarding your testimony comes from photographs. Is that correct?
Objection, that does mistake the testimony.
Sustained.
Regarding the coloration of the wounds, do you have any firsthand knowledge of the color of the wounds other than from photographs on the two decedents?
As I told you, I did examine the bodies briefly on the 13th, and I saw some of the major wounds, but almost most of the other wounds which were in the covered areas of the body was from photographs, yes.
On the 13th, did you dictate any memoranda as to what you observed?
No.
Did you write any notes as to what you observed?
No.
Did you file any notes as to what you observed?
No.
Did you make any measurements as to what you observed?
No.
So you have nothing other than your memory to rely upon to refresh your recollection as to what you observed on the 13th.
That is correct.
And you've told us that as a supervisor, you literally view thousands of bodies.
Over the year, yes.
And this has been over a year.
I mean, over a year means, over a stretch of a year, we do hundreds of and thousands of cases. So that is what I meant by my answer. But it's a year since I reviewed these bodies. That is
So
correct.
you've seen thousands of cases since then.
That's correct.
And with no notes to refresh your memory, it'd be very hard for you to describe with a medical degree of certainty the wounds, the coloration that you observed on the 13th. Isn't that correct?
That's correct.
So you are relying entirely on photographs when you form those conclusions.
That is correct.
And on photographs, you can't measure depth, can you?
No, you cannot.
Now, is there a term in forensic pathology that takes a wound and puts it together called reassessment? You ever heard that term?
I've not heard the word reassessment. I've heard the word approximation when you put the wounds together, edges together.
Reapproximation?
That would be a better term I would use than what you used.
We'll go with your term. And when you reapproximate a wound, that is to try to put it back to the position it was in at the time the injury took place. Is that correct?
Yes.
And what efforts did you make in coming to your conclusions to reapproximate any of the wounds on Nicole Brown Simpson?
I clearly stated that I had limitations in the photographic process when I gave my testimony on the direct exam. Do you want me to repeat it?
Let me just repeat the question.
Okay.
Maybe you didn't understand it. What efforts did you take to reapproximate the wounds on Nicole Brown Simpson before you gave this jury your opinion?
I already said I reviewed from photographs and I did not reapproximate the wounds. The measurements of Dr. Golden are those taken when the wounds were approximated.
Well, when he says they were approximated.
Yes, he did, and he dictated that he approximated the wound.
Did you see him do it?
I didn't see him do it.
And you've already told us he's made lots of mistakes.
I also said that they were not significant mistakes.
But
I told that they don't have significance to the matters which concern the case. There were no mistakes on the wounds which caused the major fatal injuries on both the victims.
Are you medically certain that there are no other errors that Dr. Golden made in this autopsy?
I have truthfully discussed all the errors which I believe are there, but as I also opined that the significant injuries which I could evaluate, I could give an opinion on, and I believe that the errors which were addressed had no significance to my final opinion.
My question, I'm sorry, finish.
I'm finished.
Are you medically certain that Dr. Goldman made no other errors?
To my knowledge, on the review of the case.
I didn't understand that answer. Can you answer yes or no? Are you medically certain that Dr. Goldman made no other errors?
Excuse me, I will object. It's asked and answered in argumentative.
Oh. Could you repeat the question, sir?
Are you medically certain Dr. Goldman made no other errors?
To the extent I've reviewed the case, yes. I mean, to the extent I've reviewed the case, no. I don't think he made any other errors to the extent I've reviewed.
You don't know whether he overlooked something that may be important?
Well, from my review of the photographs, there was nothing else which was overlooked on the case from what I've already opined.
So you are saying that a photograph is a substitute for an in-person autopsy by a medical examiner?
I didn't say that. I never said that.
Is that your opinion?
No, it's not my opinion. I never said that.
Oh, that's what you're going on, isn't it?
Well, under the circumstances, yes.
Now, you were shown a picture in a standard text of a wound that was reapproximated. Is that correct?
Yes.
And did I understand your testimony that the purpose of that was only to demonstrate for photography, but that wasn't a method that was actually used?
No, my understanding is that I thought I said that on approximation, you will find that the length of the wound will be greater than the wound measurement when it's gaping, and the true reflection would be when you approximate the wound and take the measurement, and that's what I remember stating. But
Isn't it true that you cannot, as a medical examiner, correctly measure a wound from a photograph unless it's been reapproximated, sir?
yes,
And that wasn't done in this case, was it?
not in my review, that's correct.
You put a lot of emphasis in your testimony on the color of the wounds. Is that correct?
Yes,
Are there different degrees of color in photographs?
yes,
And do they vary based on lighting?
yes,
Do they vary based on the type of equipment that is used?
yes.
And is there something that forensic pathologists use to measure color called a color slide or a color standard? Is there something like that?
I'm not a photographer, and I do not know about this color standards, but the photographs which are developed clearly demonstrate the wounds, and I have already given my opinion on it.
So you're not aware of anything called a color chart that is taken simultaneously with a photograph to compare colors?
As I told you, I'm not a photographic expert, and that's not my area of expertise.
But you are testifying from photographs.
That is correct.
And would you agree that colors in photographs may vary due to the printing process of those photographs?
I've already said that I'm not a photographic expert, and I don't want to go into that.
Are you familiar with a process known as microscopic slides?
Yes,
Are microscopic slides something that is commonly used in forensic pathology?
yes,
And would you agree that you can better age abrasions and contusions from microscopic slides than you can from photographs?
yes,
What microscopic slides were taken of the skin areas of Nicole Brown Simpson?
none were taken.
What microscopic slides were taken of the skin area of Ronald Goldman?
None were taken.
When was the first time you decided? Well, let me ask you this. Did you decide on your own to independently review the findings of Dr. Golden?
That was when the addendum was prepared. I looked at the case, and I brought his attention about the missed contusion, and he brought to my attention some of the injuries which were not described in the original report, and that is the time I discussed that with him. Yes.
My question was, did you decide on your own to reevaluate the work of Dr. Golden?
No, I did not.
Did someone ask you to reevaluate the work of Dr. Golden?
I did that reevaluation when the district attorney wanted me to testify. Yes.
And who asked you to do the reevaluation of Dr. Golden?
Actually, initially I was considered as a possible witness during the latter part of last year, but this year when Mr. Kelberg and Mr. Lynch came to see me, I was told that I would be testifying, and as that's the time I really started an intensive review process of the case.
Could you give us a date?
Yes.
You have your logs with you today?
Yes, I think I gave you a copy yesterday.
Yes, you did.
Okay.
Do we have that copy? You have that? I think you did provide it. I don't know whether we left it here or not, but go ahead. Will that refresh your memory, sir?
Yes, I have to look at the log sheet. Sometime the beginning of this February 8th, I had my first conversation with Mr. Kelberg.
So let's see if we can answer the question specifically. When was the first time your notes reflect that you were requested to reevaluate the work done by Dr. Golden?
This intensive is February 8th of this year.
And that was by Mr. Kelberg? I'm sorry.
Yes.
When was that the first time that you began to focus on reevaluating the work of Dr. Golden?
No, I already said that we addressed some of the errors in the addendum report in July. The
What, may I just stop you there?
Your Honor, I'd ask the witness an opportunity to.
Overruled at this point because we're getting two different answers.
Thank you.
Proceed.
And in July, who initiated the reevaluation work?
Actually, it was June 30th when I evaluated the report for the addendum preparation.
Who initiated the work on June 30th?
That was me and Dr. Golden.
You did this on your own?
Yes.
And why did you decide to reevaluate the work on June 30th?
As I told you, there were some errors found. One was the confusion which was there in the storage tissues, which was not addressed. And the other issue was Dr. Golden had some injuries which were not addressed, which were in the photographs. And he had finished his recent review of the case. And I instructed him that you need to address these issues. And that's how the addendum report was prepared.
So prior to that, you yourself, as the chief medical examiner, did not undertake any reexamination of Dr. Golden's work. Is that correct?
On these cases, yes.
And it was only when Dr. Baden and Dr. Wolf, who is not here today, through myself, made an appointment to come review your findings that attention was first focused on errors. Isn't that true, sir?
At least the brain contusion part, because the errors which Dr. Golden had in his mind would have been also addressed, because that was not addressed in the meeting with Dr. Barden and Dr. Wolf. The only lesion which I felt I should definitely correct was the contusion part of it. The rest of the addendum report was Dr. Golden's own initiative, which resulted in the addendum report being prepared.
Regarding the brain contusion, is it correct, sir, that on June the 22nd, at the request of myself, to bring in Dr. Baden and Dr. Wolf to reevaluate the autopsy, for the first time, the brain tissue was brought out for reexamination based on their request?
That is correct.
And at that time, Dr. Baden was dictating notes to Dr. Wolf, was he not?
Yes.
And you were also taking notes of what Dr. Baden was dictating, were you not?
I was taking notes of what Dr. Barden was taking and also what I was observing.
And you took notes when Dr. Baden observed the injury to the brain, did you not?
Well, I also observed the injury at the same time because I was working with him at the same time.
Did you take notes
Mr.
of
Gary,
Dr. Baden's findings regarding the brain? Yes or no?
I took notes of what I observed, but Dr. Barden also observed the same thing and he took his notes. I was taking notes off the meeting to record it for posterity.
Did you turn those notes over to the defense as required by discovery?
I turned over the typed report, which was present, which was a final report, yes, and I also turned over the notes to you, I think, a few days ago.
And did those notes indicate they were your findings or Dr. Baden's findings?
They were my findings and his findings, yes.
Actually, it was really obvious what the injury was, wasn't it?
Yes.
But it was at Dr. Baden's request that that sample jar be brought out.
Ask him the answer.
Overruled.
Yes.
Did Dr. Baden and Dr. Wolf ask to be able to take photographs of their findings?
I don't recall that because we did take photographs of the evidence, but during the histopathological process, I don't recall them requesting it.
Do you recall denying them the right to take photographs, saying that they couldn't?
That I said that as a general rule in our department, we don't allow outside people to take photographs. We take the photographs and provide them copies. But I don't recall that they wanted to take photographs during the tissue examination process. But we did take photographs during the other evidence examination process.
But you know Dr. Baden for a long time, don't you?
Yes, I do. He takes a lot of photographs. I know that.
And you trained under him, didn't you?
Yes, I trained under him for 2 years on a part-time basis.
Is there any reason why you would not allow him to take photographs in your laboratory?
We have procedures in our department, and we can't break rules just because I know somebody and I am friendly with them. I have to follow the rules of the department because I established these rules so that we have control on the photographs being taken in the department.
Did Dr. Bowden try to talk to you as a medical examiner about the findings while you were there?
No.
Didn't you tell him that you were instructed by the district attorney that you couldn't talk to him?
I think I told you that also because I didn't tell you about the district attorney not asking me to talk to you. I told you that I won't be able to talk to you on the case because the case was in grand jury at that time. And Dr. Golden was not present because he was testifying in the grand jury. So if that is my understanding of our conversation, if I remember right.
So you did instruct Dr. Golden, I'm sorry, that Dr. Bowden that you could not speak with him,
About the case, yes.
even about medical findings that would commonly be shared by forensic pathologists.
At that time, yes. Because the case was in grand jury.
Isn't it true that the only slides that your office made at your own direction was after Dr. Bowden asked for the brain tissue to be examined?
That is correct.
And isn't it true that the only other microscopic slides that have been done in this case were done recently at the request and expense of Dr. Bowden, Dr. Wolf, and myself?
That is also correct.
By the way, how much did you charge us for those slides?
If I remember right, the department charged you, not me. The County of Los Angeles charged you $1,393.60, if I remember right. But I can pull out the invoice.
And that was,
I can verify that number, but that is my recollection of the number, $1,393.60. But I can correct it, subject to review of that
and we were
invoice.
charged for your time?
No, basically what has happened was that the county has some fixed rates when tissues and slides are made from tissue processing, and you were charged for 16 slides at the rate of $80+ per slide, and that is what the county charges, yes. And that includes my time also, or any doctor's time.
And how much an hour were we billed for your time?
You are not billed for my time. You only billed for the slide cost.
Are you sure of that?
Positive.
So if I have a bill for your time, we'll get a refund?
Yes, because the time, the amount of money you were charged is, the doctor's time is built into it. The county has some procedures.
And the $80 a slide.
80 plus, I said.
80 plus.
Yeah.
80 plus. All right, let's say 80 for the sake of this discussion. Would you say that the going rate in forensic laboratories around the country for such a slide is $5?
Objection, Your Honor. Calls for hearsay, lack of foundation.
Overruled. I think you're confusing the picture here. Maybe I should explain this a little bit in detail. The cost which you're paying per slide includes the initial phone calls you make. The county takes a lot of things into consideration. My clerical person answering the phone call, our conversations, our being present. And remember that during the process, we took extra photographs, which we didn't charge you for. We gave you the photographs free because we wanted to document whatever I think is necessary, which needs to be done on a case, is given to both parties without any cost. It is something when I don't feel is necessary and is requested by another party, then the county charges for that request, number one. Number two, if it's just a duplicate of a slide which is being made, is done at a much lower cost. And with reference to the only slide we made was the brain contusion slide, that we gave the duplicate free. We didn't charge Dr. Barden for it. We didn't charge Dr. Barden or yourself for the initial set of photographs. We didn't charge you for anything. Whatever we gave the prosecution, we gave you. But what we did charge was for the extra effort the department made for the additional sections, which in my opinion were not adding anything further to the cause and manner of death in this case, was charged to you. And I think the charge is what the county sets up based on from the clerical call to the histopathology technician going and retrieving the jars, his time, because he has to stop what he's doing, bring these jars from storage, and then we have to give it to the processor. When the processor processes slides, they have to come back. All these charges are built in. And then, since we generated slides on a case, even though it is requested by another person, we still have to look at the slides because it's our case. We have to generate a report. I mean, all these costs are built in. And then, and that's how those charges come. So it looks a large. This is similar to what the hospital charges when you get a Tylenol from the hospital. They have the built-in cost of running the whole show. It is just not the slide cost. It's not like buying retail. It's a whole process, that's what the auditor does. I just try to explain my understanding of the process of why the cost should be so much.
Next question.
Do you recall the question I asked?
Yes, you did.
What was the question?
Your Honor, objection was argued.
Sustained.
Didn't I just ask you, isn't it the standard cost in labs around the country that the cost is $5? Can you answer that yes or no?
Well, but it won't really explain the question the way you phrased it, because it looks.
Thank you. Let's move on.
Isn't it true, doctor, the best way to determine the aspiration of blood into the lungs is to examine microscopic slides?
You can tell from grossly also, but microscopically you will see the aspirated blood, but in gross examination you can see aspirated blood very clearly, because to get to the tip of the lungs, which you're going to do microscopic, you'll have to see the blood in the trachea and the larynx first. It's the initial pathway from where the blood reaches the lungs.
Is it your medical opinion that a better way to determine the issue of bleeding into the lungs or aspiration of blood into the lungs is by microscopic slide or relying on somebody else's visual observation?
Your Honor, I object. They, we ask aspiration of blood or bleeding.
Aspiration
Sustained.
of blood.
You understand the question?
Because you sustained it, so I don't know what the exact.
No, he just restated the question. Why don't you restate the complete question?
Regarding aspiration of blood, would you as an expert medical examiner say it would be a better way to make the determination by a microscopic slide or relying on a medical examiner who has made numerous mistakes in an autopsy?
It depends on the issue you're trying to study. If you think by gross examination the bleeding was acute, which was from a fracture of the skull or whatever the reason for the aspiration was, you don't need to do a microscopic study. But if you feel the aspiration occurred and you need to date the aspiration, then a microscopic study will be useful. But as far as looking at an aspirated blood, it's pretty obvious if you've done many forensic autopsies to see aspirated blood in the lungs.
Wouldn't it have helped you in this case in reaching your conclusions regarding the injuries to the neck that caused bleeding in the area of the windpipe to have microscopic slides?
Not necessary, because you have the cause of death clearly established and the injury is an acute injury.
There wouldn't be a better way, in your opinion?
No.
Would you say that a reasonable conclusion in a case involving stabbing is that the more stab wounds you find, the more likely there is that a struggle was put up?
I won't make that conclusion by the number of stab wounds, because there are other factors involved.
You've indicated that not all the blunt wounds on the decedents are in the same direction. Is that correct?
I don't know what you mean by blunt wounds, what direction, which wounds you're referring to. If you could specify your area, maybe I'll be able to give a answer better.
Are all the wounds that you observed on both of these decedents that have blunt ends to them in the same direction?
No, they are in different, slightly different directions, depending on which wound you're referring to. The wounds on Goldman, they were in different directions. The Nicole's wounds, two of them were in the same direction. One of them was in a different direction on the left side of the neck.
And that clearly indicates that there was movement between the decedent and the perpetrators, doesn't it?
Yes, I thought I opined that the stabbing process is a dynamic process. It's not a static process. I already explained that.
And because it's a dynamic process involving movement, you nor any other medical examiner has any ability to accurately reconstruct what took place. Isn't that correct?
Accurately reconstructed? No.
Now, you talked about the reaction of an individual who in this case was Mr. Goldman, and how he, in your opinion, would react to being attacked. Did you not?
Could you read that part of my testimony, and then I can refresh my memory what I exactly said, because I've been testifying for 8 days, so I don't know which part of the testimony you are referring to.
Your testimony was so long, you have already forgotten it?
Objection, Your Honor's argument.
Sustained.
Was your testimony so long that you already forgot it?
Well, there were different scenarios posed, different questions asked, so if you can refresh my memory, I'll be happy to look at the statements I made and explain it again if you wish me to do.
One of the areas you talked about were injuries to the fist.
I think,
Do you recall that?
excuse me, that misstates the testimony.
Sustained. Rephrase the question. Hands.
Did you testify about injuries to the hands?
Yes, I did.
Did you testify that you had read some literature in that regard?
Yes, I did.
Where was that article published that you read?
I just read a chapter in a sports injury textbook. It was by Fu and Stone. It's a textbook by Fu and Stone on sports injuries. It is a chapter on boxing injuries by Timothy Ward.
And when did you read that?
The last few months. And
Did anybody call that article to your attention?
no,
You just did research yourself?
yes,
And that article dealt with injuries to the hand that take place in a fist fight?
well, boxing injuries.
Boxing with or without gloves?
That's correct.
It dealt with both injuries that occur with gloves and without gloves?
Yes,
And there's something in there that you have relied upon as to what you would expect if one individual struck another individual with a closed fist?
there was information there as to the injuries they have observed in their research material. But when I opined, my opinion was based on my experience and the information I gathered from there. So my experience on seeing blunt force injuries also is there when I gave my opinion.
What information did you rely on in that article in coming to your opinion?
Well, I was just seeing what type of fractures one would get in the boxing injuries, and those are the kind of information I was looking at.
What information did you rely on in giving your opinion from reading that?
The information which was provided in the chapter, plus my experience.
And what information was that you relied on as to whether or not the victim or victims in this case struck the assailant or assailants?
I looked at where the injury patterns would happen with reference to if it's a closed fist, if it's a properly laid blow or a glancing, improperly laid blow on the person, what type of injuries you would get, what type of fractures you would get. It just improved my understanding of the injury patterns observed by sports injury orthopedic physicians.
Would you relate to the jury that section that you relied upon for that opinion?
Objection is asked and answered.
Basically, the area which I looked at was to see whether what type of fractures you can get. You can get fractures of the first metacarpal bone in a boxer who wears a gloves, but the thumb is not in the glove, and you can get a fracture at the base of the metacarpal bone. If you can get fractures of the fifth and fourth metacarpal bone, which is the outer little finger bones. If the blow is not improperly placed, you could get injuries to the ligaments on the back of the metacarpophalangeal joints, depending how the blow was applied, etc.
So what you're saying is if one person hits another person, they could hurt their hand,
Yes.
and you needed to do research to find that out.
Objection, Your Honor, is argument that it's
Sustained.
How much research did you do to find that out?
Well, read the chapter which just improves my knowledge base on it. But as I already told you, my opinion was based on also our own experience on different blunt force trauma you see in the hands of different individuals.
How many bare hand fights have you actually witnessed?
I have not witnessed bare hand fights, but I've seen people who have died from altercations, who have had fights and who have injuries to the face and hands. I've seen many cases.
Is there a proper way to throw a punch?
Well, there is an ideal punch when the whole force delivers its effect on the target, and there are blows which may not deliver the entire force on the target.
What is the position of the fist in a proper punch?
Do you want me to demonstrate, Your Honor? This would be one way of holding a hand to deliver a punch.
For the record, Your Honor, with his right hand, Dr. Lakshmanan has closed his hand into a fist. His arm is at perhaps a 45-degree upward angle.
Yes.
Could you hit somebody with your hand in that position and cause injury to them?
Well, I've not hit anybody closing my fist, but you could cause definite blunt force injury by hitting somebody hard with this kind of closed fist.
Could you cause injury to somebody by hitting them with a closed fist and not cause injury to yourself?
It's a possibility that you may not get injured, but you could also get bruising of your hands. That's why you can get bruising of the hands too.
So you could get hurt, you could not get hurt.
That's correct. And I think, stated that if there were gloves present, there's less chance the person striking somebody would get hurt, and the person who gets hit would get hurt more.
Is there something known as a glancing blow?
Yes. And that what would be the one which the blow did not have its full effect on the target, either due to movement of the target being the victim and the reach was not as it was planned to be delivered.
So it's possible if someone hits someone improperly, that they could only hit with one knuckle or one portion of the hand and not cause injury to other parts of the hand.
Generally, that could happen theoretically, but if you hit the knuckles, you will expect other bruising of the other knuckles in that situation.
What if you only hit one knuckle on the chin?
Well, that's always a possibility, I suppose, but generally, if you look at it in context, you will get injuries to other knuckles too.
Even if you only one knuckle came in contact with someone's chin?
I said it's a possibility.
You would expect injuries on other knuckles?
I said in your theoretical possibility, your possibility that if only a glancing blow with only one knuckle hitting, then that's a possibility, I suppose. But if you look at it logically, it doesn't make sense that you would only hit one knuckle on somebody, especially in the case of Mr. Goldman, when you have a clear-cut bruise on the middle finger knuckle, it seems unlikely that you would not see bruising of the other knuckles, especially when the knuckle which is injured is in the middle of the closed fist.
Doesn't the middle knuckle protrude in most people's hands more than the others?
The other knuckles protrude too. Also, your index finger knuckle protrudes. If my hand, if you look, you can see that both the knuckles protrude.
Did Mr. Goldman's index knuckle protrude?
I didn't close his fist to see that, but just from my experience, this is the average appearance of a closed fist. And I think if you take the closed fist of most people, this is the appearance it'll have.
Have you done any studies in that?
I have not done studies on that, but I'm just giving you from my experience.
What experience is that?
Experience means my knowledge on this.
Where did you obtain this knowledge?
It's practical knowledge. If you close anybody's fist, you can see the appearance.
So general knowledge that all of us have.
That's correct.
If someone was attacked from behind, would you expect that the victim would try to kick the assailant?
That would depend what kind of attack was from the behind. So could you expand on it a little better?
Well, you did that demonstration. Maybe you can, remember with Mr. Kelberg, you grabbed him with one hand around his chest and you held a ruler to his throat. Remember when you did that?
Yes.
Now, if Mr. Kelberg was fighting for his life, would you expect that he might try to kick you to get away?
That is a possibility, and I did mention it in my opinion that the victim could have wrestled himself away from the assailant, and a normal human being is not going to just allow somebody to cut your throat. You're going to try and escape from that life-threatening situation.
Well, so the reasonable thing to expect is that there would be a struggle,
Yes,
and that the victim would try to kick,
that's a possibility.
would try to hit,
If the victim is being held, yes,
try to hit with closed fist,
it's a possibility.
with an open hand,
It's a possibility.
with elbows,
It's a possibility.
with anything else in the natural instinct to survive the attack. Isn't that true?
That is correct.
Have you, now part of this you say is you go through all these scientific things that you've studied, and then one of the criteria is witnesses, to ask people what really happened, or to ask about reactions of people. Is that part of your job?
No, I don't talk to witnesses because we just do our autopsies and review the injuries.
In forming your opinion, wouldn't you like to know if the victim was physically fit?
Well, from the appearance of the body, he appeared to be an athletic young man who was not obese. He was very athletic, handsome young man.
Wouldn't you like to know if that is the person who is likely to perhaps just kowtow to an attacker and melt away and not do anything, or whether he's the type of person who would in fact try to defend himself and put up a struggle?
That's a difficult question to answer because you're going to areas, because sometimes you can have a very big person who can be intimidated by fear. And so I don't know what exactly happened, but theoretically, a physically athletic person could definitely offer resistance. But if there's fear element involved, they could be just intimidated and just freeze. And that's also known to occur. So I really don't know what happened. But I do know what injuries happened, and I've given you my opinion on the injuries as what could have happened.
Would it have helped to talk to somebody and ask what the makeup of the victim was and what the victim would likely do?
I didn't do that.
It's a compound question.
Oh.
What about Nicole Brown Simpson? Was she physically fit?
She looked like a young, physically fit woman, yes.
Is there a difference between the way women react to an attack and men?
Well, I can't say that because nowadays, not nowadays, any human being can react in the same way in a situation of stress. Either they can fight the attacker or they can be in fear and freeze. So I don't think a difference of sexes matter. It is the situation in which the person is put into place.
Would it be unreasonable to expect that a woman would fight off an attacker?
Well, I would expect any human being to fight off the attacker if they are not frozen by fear.
And
You're
then
fighting for your life.
And in such a fight for your life, you would expect the attacker or attackers to have some injuries or evidence of being in some type of struggle, wouldn't you?
if the victim was able to deliver some blows, but if the attacker quickly incapacitated them, you may not see injuries on the attacker. So it depends on the situation. I'm just giving you my understanding of what could happen, but I've already discussed what injuries each one had, and I've already discussed what my opinion on both the victims are. It's in the evidence, and we could go over the transcript if you want.
You told us the minimum amount of time the struggle between Ron Goldman and his attacker or attackers was. And you said it could be less than a minute.
Yes, I did that.
What is the maximum amount of time the struggle could have taken place between Ron Goldman and his attacker or attackers?
I would say within a few minutes, because of the nature of the injuries and the acute bleeding, I wouldn't expect the attack to be more than a few minutes, because you can't really tell with how long, but I would favor it within a few minutes the attack took place. But it could have been done very well within a minute.
What if the fatal wounds were the last wound struck?
There were quite a few fatal wounds. He had 2 wounds to the chest, 1 wound to the neck, which caused bleeding from the jugular vein. He had an aortic wound. The thigh wound was not fatal, but it was still causing significant bleeding. The only other wounds you are left with is 3-4 cuts in the 2 cuts in the top of the head, in the back of the head, and you had blunt force injuries to the hand. So I think the injuries which were inflicted to him were significant injuries, and I think they could have been done very well within a minute, and I would not expect the struggle to be in more than a few minutes based on the injuries I see. So unless there's any other possibility you want to offer, and we could discuss it.
All right, well, let's assume Mr. Goldman was in very good physical shape, that he's 25 years old, that he's 6 feet tall, that he works out regularly, and that he is not taken by surprise, but he sees attackers, and he puts up a really valiant struggle. Is that something that could take place?
Could you explain what you mean by valiant struggle? What
He
exactly
fought
happened?
real hard. He fought his attackers real hard.
In what way?
With his legs, with his hands, with his fist, with his body.
As I already told you, I don't think he fought the attacker in the manner you're portraying, because he was trying to avoid the wounds as I see it. I think Mr. Goldman was mainly ducking, turning, twisting, and backing when these injuries took place. And I already mentioned that he was in a closed environment. And in my own feeling, he was rapidly incapacitated. He didn't have a chance. The injuries I see, most of the hands are on the fronts of the hands. There's no cuts in the back. So my feeling is he was turning, twisting at some point because of the nature of the clothing injuries we have. He was ducking because he's got injuries to the back of the head if he was facing the assailant, and most likely backing into the bushes with his flailing hands when the attack took place. And that's my opinion. From what I can see in the injuries, we have discussed it.
Your opinion is that a person or persons with a knife came at Mr. Goldman, and rather than trying to cover his head and face, or trying to bend over to protect himself, or trying to get into some type of defensive stance, he just put his arms out and started hitting a tree and a fence. Is that your testimony, sir?
Well, the point is he doesn't have any injuries in the back of the hands. In your demonstration, you just said if he did this, the man has got wielding cuts in the left side of the neck. He's got cuts in the left side of the neck, in the face from the wielding knife. So from your demonstration, he should have a lot of cuts in the back of the hands, which he doesn't have pathologically. You saw the photographs, I saw the photographs. There are no back, and there's no injuries to the back of the hand.
Is it your testimony that he did not try to defend himself, but rather threw his arms out and hit a tree and hit the fence?
Let me put
Is
it this
that your
way.
testimony?
No. My testimony is that the injuries I see do not support that hypothetical situation. It supports rather a situation which I already opined. He backed, he ducked, he turned, he twisted, and he didn't have a chance.
And you based that solely on viewing photographs?
Photographs show the injuries, and the description of the report is available for my review, and it's an independent review.
And are there other experts whose opinion you trust who could give different scenarios?
I'm not.
Your Honor, that calls for speculation.
Sustained.
Based on your expertise, are there others who would disagree with that opinion?
Objection, Your Honor, is calling for hearsay, speculation, and irrelevance.
Sustained.
You talked about the tip of a knife and that there was no evidence that any tip of a knife was broken off. Is that correct?
Yes.
Was a correct examination done to look for a tip of a knife?
We didn't do X-rays before the autopsy, so, but we did do X-rays after the autopsy, and on the only bony structure which was injured. So that way, we did an examination for any foreign body.
The X-ray that you did was of what size of the spine?
The X-ray was just of the spine specimen we removed.
What size was the spine specimen as compared to the entire spine?
It was only 3 pieces of the vertebra.
How large were those 3 pieces of the vertebrae?
There were, one portion was a portion of the vertebra, the other 2 were intact.
What size were they?
The vertebral size, which is a normal size, with a couple of inches length of the spine, which was removed, which was X-rayed, not the entire spine, no.
Would you show the jury, with just holding your hand, what size of a portion of the vertebrae we're talking about?
We had a length of the spine of this length, approximately. Each body is about so much, so you're talking about this length of spine, which was examined.
Approximately 3 or 4 inches.
Is it a medical possibility that if the tip of a knife broke off in that area, that it could dislodge itself without a medical examiner finding it?
Generally, no, because usually when the knife tip breaks, the knife tip is stuck to the bone. In my experience, I have had 2 cases where we have seen this. The tip which is broken is embedded in the bone. They won't fall off because what breaks it is the tip gets stuck. And when the knife is twisted, the tip breaks and it's embedded in the bone. At least in my experience, in the 2 cases I have been involved, the knife tip gets stuck and you have to literally take it out of the bone with the help of X-rays. So to answer your question, I don't think it's likely.
So based on those 2 times that you have seen a knife tip in a bone, you would opine that it is not reasonable that a knife tip could become dislodged and go to another part of the body?
Generally not. That's my feeling on it from my experience because, as I told you, the tip is the one which gets broken. The tip is usually very small. It's not a big chunk which gets broken. And the tip gets stuck in the bone, in my experience, and I'm going with my experience.
Is it possible that the tip of the knife or knives could have been broken in any other portion of the body other than that small fragment of spine that you saved?
Generally not. Usually the knives break when they hit bony structures because when you have a soft tissue structure and you have a sharp instrument, there is no resistance. You usually break an instrument when there is resistance, and the resistance is compounded by the tip getting stuck somewhere. So in my experience and my reading of the subject, it would be most likely if the knife struck a hard bony structure and not a soft tissue structure.
Now, to ask the question the way they were asked on direct examination, could someone be cut with a knife, have the tip broken off, and have it not lodged in the only small area of the spine that you recovered?
As I told you from my experience, I don't think that's very likely, but unless you have some information which you can provide me which shows that has happened in other cases.
My question isn't it likely? My question is, could it happen?
Theoretically, it's possible, but from what I just opined, medically, it doesn't seem possible.
And wouldn't the best way to determine that be by taking an X-ray?
Yes,
And X-rays were not taken in this case.
I've already said that.
And they were not taken because the X-ray machine was broken?
I don't have an exact answer for that. I don't think the doctor felt it was necessary to do it at that time. But when I got involved in the case later, I ordered the x-rays to be done on the spine, which we have. And
How much?
most importantly, during the examination, Dr. Golden saved the only bony injury he observed, which was the spine. He saved it for storage.
How much later did you take the X-ray? Order the X-ray to be taken?
I have to refer to the report, but I think it's sometime in September of last year when the x-rays were done, and I asked our radiologist to look at it.
Well, what happened over 3 or 4 months to cause you to feel that X-rays that weren't taken on the 13th were proper to take?
Well, I just felt to complete the process just to make sure that we didn't miss anything. I just wanted to make sure because the wound patterns didn't suggest the knife was broken. The wound patterns didn't suggest, but I felt to complete the process, we need to do that to make sure we didn't miss anything which may be of importance in the case. And I just completed an investigation, just like I ordered the C-screen. I ordered this also to complete the process to make sure that we didn't miss anything.
Because you felt those were the proper things to do.
Well, you can put it that way, yes.
And if they were proper to do in September, they were certainly proper to do in June, weren't they?
Yes, but I also said that we saved what was essential, what Dr. Golden saved the only major bony injury he observed on both the cases in storage. We had the specimen.
But you're relying on somebody's observations who you've already told us makes lots of mistakes.
Excuse me, Your Honor, that misstates the testimony.
Makes mistakes.
Are we limiting?
It's an argumentative question. Rephrase the question, please.
You're relying on the opinion of someone else who you have already told us has made several mistakes in this autopsy. Isn't that correct?
Yes, but I also said they were not significant as to the outcome of the case. There were some mistakes, but they were all of the non-lethal injuries.
As you testify today here as an expert, would you say that a certified medical examiner should know the difference between an entrance and an exit wound caused by a bullet?
Yes, but there are difficulties even for the most experienced pathologists sometimes to differentiate an entrance and an exit when you have what's called a short exit. So, but I agree that a pathologist should be able to tell, but sometimes it's difficult
Okay.
in certain situations.
And you told the jury here yesterday that Dr. Golden made such an error.
I did say that, and it is the truth. He did make an error on that case.
And you also, would you also opine that a board-certified medical examiner should know the difference between a gunshot wound that is fired at a distance and one that is fired at close range?
Yes, and I opined on that also yesterday.
And Dr. Golden, you told us, made that mistake.
Yes, he did.
And do you think an expert board-certified medical examiner should be able to tell whether or not a thyroid is present during an autopsy?
Yes,
And you told us that mistake was made by Dr. Golden.
yes, but that mistake is something on somebody who's on thyroid therapy. And anyway, that is a mistake, yes.
And you still rely upon what Dr. Golden did as being correct in forming the basis for your opinions in this case, don't you?
Yes, I do. And the reason is he has done 5,000 plus cases. I know him personally as a pathologist. And I know he's a capable doctor, and I've seen his work on other cases. These are mistakes which have been acknowledged, and I have no hesitation why I can't rely on this report.
You know, in the case where there were 2 people who were victims with the gunshot wounds that we talked about yesterday, Mr. Kelberg brought that up, that you said addendums were filed in those cases to correct the mistakes.
One addendum had been filed. When I reviewed the cases, the second addendum was filed on the addendum on the second case was filed, and I also had to make a correction on the first case at that time.
This was an autopsy that took place in 1990.
That's correct.
And a case that was prosecuted as a capital murder case.
Objection, Your Honor, and counsel indicated.
Sustained.
In this case, one correction was made in 1993. Is that correct?
I have to look at the papers, but that sounds about right.
Was the se-
I'm sorry, in this case, you said.
No, in the case that we're talking about.
All right.
In the case we're talking about where the errors
That-
were made regarding the gunshot wounds.
That sounds about right, but I would like to refresh my memory.
Were
of the
both
date.
errors corrected at about the same time?
No, the second error, the error on the other case, the close-range gunshot wound versus the distant wound, that was done last year, in '94, when I found that addendum had not been done. I directed Dr. Golden to do that addendum. The other error on the change in direction was done probably '93. I don't recall the date exactly. And so the addendums on the two mistakes were done at two different times. One at my direction, since it had not been done, and one which was done by Dr. Golden himself earlier. In 1994, I also directed a change in the addendum on the other case because there was a typographical error on the number. They had typed 9679 instead of 9678, and that addendum was made. So to summarize, we did one addendum in, if it's '93, I don't recall the exact date, but in '94, two addendums were issued, one for each case, one for the number change and one for to reflect the range of fire.
All right, may I just finish on this line of questioning? So to get the sequence of events, two people were killed relatively in the same crime scene in 1990, and autopsies were done by Dr. Golden.
Yes, sir.
In one case, he said that he missed whether or not it was a point-blank injury from a distance injury. Is that correct?
Yes, sir.
And in the other, he made a mistake as to whether it was an entrance or exit wound.
That is correct.
The mistake in one of them was corrected in June of 1993.
If that's the date, I said I had to refresh my memory.
Let me get those for you. And the mistake in the second case was corrected in September of 1994.
Yes.
Were both mistakes discovered at the same time?
Well, that is my understanding.
All right, ladies and gentlemen, we're going to take our mid-morning break. Please remember all my admonitions to you. We'll be in recess for 15 minutes. Back on the record in the Simpson matter, all the parties are again present. Jury is not present. Counsel, anything we need to take up before we invite the jurors to join us? All right.
Can I ask Ms. Robertson? Actually, you have the mark for Bureau, the driver's license?
No. So that should be 1193. It's already, the original is already in evidence.
I had Mrs. Robertson bring that up because I thought the original Ronald Goldman driver's license was in evidence, but what we have is a Elmo picture of it,
I see.
and it is not readable from the Elmo.
So what designation does that have?
That is People's 85. That's People's 85.
You want to just, I don't know if Mr. Shapiro has some, need to have it as a defense exhibit designation, or if you want to just make it 85A.
Let's make that. Mr. Shapiro,
Yes.
I would prefer to have that as 85A so we have all the Ronald Goldman driver's license
That's fine.
in the same genre, so to speak. Okay, let's have the jurors. Let the record reflect we've been rejoined by all the members of our jury panel. And Dr. Lakshmanan, would you resume the witness stand? Doctor, you're reminded, sir, you are still under oath. And Mr. Shapiro, you may continue with your cross-examination.
Thank you, Your Honor. Hopefully, we will try to conclude by the recess this afternoon. Dr. Lakshmanan, is trace evidence important to a medical examiner?
Yes.
Is preservation of trace evidence important to a medical examiner?
Yes.
And for proper preservation of trace evidence in a homicide, is it proper procedure to bag the hands of the decedent?
We do it if, in cases of firearm injuries, we don't do it routinely in our office.
Is it acceptable proper procedure throughout the forensic science community and pathology?
Well, I just told you what is done in our office. We do it on certain types of cases, not on all cases.
Is trace evidence susceptible to being on the hands in a case of a knife attack?
Could you tell what type of trace evidence you're talking about?
Any type of trace evidence?
You mean-
Hair, fibers, blood from someone else, skin from someone else. Would any of those things be important to a forensic pathologist?
If we observe it, yes.
Would you say that bagging the entire body protects the hands during transportation from a crime scene to the crime lab?
That is not our procedures, but I wouldn't object to that.
Would that protect the hands if there was trace evidence on the hands by bagging the entire body?
No, it would be preferred to, if you have suspicion of something you want to collect and you want to preserve it, then bagging would be an option.
Is it the policy of forensic pathologists that when bodies are moved for transportation, that they should be kept in the same position they are found to preserve trace evidence and bloodstains that may be on the body?
In our office, if the investigator feels that is necessary, and if it cannot be collected at the scene by our criminalist or other person, then they would do the necessary procedure which would preserve that evidence.
Isn't it true that if the position of the body is changed in transportation, bloodstains may be smeared and contaminate other trace evidence?
It's a possibility, I suppose, depending on what type of evidence you're talking and where it is located and what position the body was on when transported.
Do you know if Dr. Golden examined the bodies of the decedents in this case prior to them being cleansed and washed?
Yes, he examined the bodies on the 13th, and I think he examined them again on the 14th.
Did you examine them with him?
I examined the bodies briefly on the 13th when the bodies were brought in, and I was the one who assigned the cases to Dr. Golden, who also volunteered to do the cases. And then after that, I don't know how many times he saw the bodies on the 13th or the 14th, but on the 14th, he did see the bodies during the photographic process.
Did you yourself do a careful examination of the bodies for trace evidence?
No, I did not. I just did a brief examination and to see the extent of the injuries, and I had to make a decision on whom to assign the case. So I did not do a detailed examination. No, sir, I did not.
Did you observe Dr. Golden do a detailed examination for trace evidence before the bodies were washed and cleansed?
I didn't observe him on the 14th. I already said that.
Does the coroner's office have video equipment?
Yes, we do.
Were videotapes taken of the postmortem examinations of Nicole Brown Simpson and Ronald Goldman?
No.
In conducting your work, do your personnel use head coverings and shoe coverings?
Yes, we do.
And is that because you're concerned about contamination?
No, the clothing we wear is for our protection. We have universal body and blood fluid precautions in our department. And all our employees who enter the high-risk areas, which is our autopsy room, are provided with all the apparel necessary to conduct such a high-risk procedure, which is an autopsy.
Are gloves always changed by pathologists and assistants between bodies?
Yes.
Should personnel handling the bodies at the scene wear proper covering, shoe covering, and gloves?
Yes.
Was that done in this case?
Yes.
Are you sure of that?
Yes.
You told us an sexual assault kit was not performed on Nicole Brown Simpson.
Yes.
Isn't it true that you could have done a sexual assault kit test quicker than the time you took to explain why you didn't do it in this case?
Well, I already discussed this. We didn't take it. I was asked why we didn't take it. I gave an explanation. So I don't know what more to say. We didn't take it. And I've already said that. And I gave you the reasons why the criminalist didn't take it. And I also felt we need not take it when I looked at the case.
How long does it take to do a sexual assault kit?
It's a procedure which takes some time because the criminalist has to have a space available. Photographs are taken during the process as the case may be necessary because you have to remove the clothing. So you're talking anywhere up to an hour of time involved of different personnel.
1 hour it takes?
Within an hour, approximately less than an hour, depending on what needs to be done.
Less than an hour?
Yes.
How much less than an hour?
Well, it depends on the criminalist who's doing the procedure.
Well, let's talk about a board-certified senior criminalist. How long would it take that person to
I
do?
think we're mixing up our terminology here.
I probably am.
Criminalist, not pathologist.
Yes, pathologist. Thank you very much, Your Honor. A board-certified pathologist.
In our department, the pathologists don't do the collection. We get the criminalists to do it because they are better trained to do it than us, and we have the luxury of having them in our staff. So they do it for us.
How long does it take them to do?
I said within an hour. I guess it could be done within half an hour, depending on the skills of the criminalist.
How much does that kit cost?
I don't know the cost, sir.
Is it expensive?
It's not expensive.
In trying to establish time of death, one of the factors you look for, other than the scientific factors, are witnesses. Is that correct?
I said yesterday on the testimony, independent, verifiable evidence of witnesses.
And also, if there was evidence of consensual sex, might not that be of some benefit in assessing time of death?
No.
Well,
What you will get there is only the post-coital interval, and even that is very vague and non-specific in its estimation. You cannot get time of death from the intercourse, from just doing a sexual assault.
But if you did a sexual assault kit, would that verify whether or not there may have been sexual, consensual sex prior to death?
It may reflect that.
And if a person's pattern could be established when they might have time alone to engage in consensual sex, could that be of some benefit in assessing when this person was last alive?
It won't have any benefit on when the person was last alive because you cannot make an estimation of time of death from the sexual assault. Even the basic aim when you do that is to see the post-coital interval. You can only try and tell when the coitus took place, but even that is a very vague subject because of the various variabilities involved in this.
What if you established that a person was in this courtroom the entire day except for 1 hour during lunch, and then did a sexual assault kit and found out that person had some type of sexual relationship? Would that help you determine time periods in any way?
It's very difficult to estimate time periods because I already said there's so much variability. As I said, let's take even the sperm motility. I said sperm motility is within, usually it stops within 4 hours, but it could be longer too.
Let's try to be practical. Let's say this morning somebody was in this courtroom, it would be clear they didn't have consensual sex while they were here. Is that correct?
That is a fair statement.
And if they came back from 1 o'clock to 5 o'clock and they didn't have consensual sex with anyone present, that would be a fair assumption, would it not?
Yes.
And if between 12 and 1 o'clock they were not seen by anyone, and if that person expired at 5:15 and a sexual assault kit was done to show that there was evidence of consensual sex, could that be of some benefit, yes or no?
I want to know what type of evidence you're talking about, and I can't make any assumption that it's consensual or not. And all you can tell from, depending on what evidence you have in your hypothetical, if you tell that, then we can go further on that. What is the evidence which was seen at 5:15 when the sexual assault was done?
At 5:15, it was determined that the person had some type of sexual relationship. Could that be of any importance to you, yes or no?
Well, it'll only say that there was a sexual relationship if you find evidence of sperms or the enzymes, but it doesn't give anything further than that.
But other things couldn't it? That
No,
could
but,
be one
but, no,
fact.
but to make an assumption, you must have done a sexual assault in the morning before the court started to make sure that was negative, to make any conclusions on a result you get at 5:15, because the material could have been there for more than a day or two, depending on what the circumstances are, and because you can have coitus, it could depend on the amount of ejaculation in the body. It could be a non-ejaculated intercourse. It could be coitus interruptus, as they call. It could be that the lady had some vaginal douches after that. There are a lot of variabilities in this, so you can't really make an assumption when the sexual act took place just because you have a sexual assault kit done at 5:15, unless you have done a sexual assault previously that morning or that afternoon to prove that there was nothing there, and then you have something there at 5:15. So again, that's why I'm saying your question is a little bit vague to give a specific answer. But
Doesn't your manual specifically say, doctor, that whenever identification of the last sexual partner may be of value to the investigation, or whenever elimination of sexual activity may be of value to it, the examination, a sexual assault kit, whether the allegations or thoughts are consensual or non-consensual, should be done?
that's correct. That if you're at the manual, and I remember that statement in the manual.
And a sexual assault kit will show other things other than rape, won't it?
It'll show evidence of seminal material there.
Which it could show evidence of oral sexual contact.
If the oral area is examined, which is part of the sexual assault kit in our office, you'll find evidence for it.
I want to direct your attention to the marks on the back of Nicole Brown Simpson that you described as bruises. Do you know what I'm referring to?
Yes, the right lower back, I remember it very well.
And to a similar area on the back of the decedent Ronald Goldman that you referred to as lividity.
On the right side of the back, yes.
Isn't it true, doctor, by looking at the photographs alone, that you cannot determine lividity from a faint, non-patterned contusion?
You can. In this case, you can, because it's very localized. Usually, lividity will take place in the whole area of the body, and that area of the body is actually more of an area. The rest of the body on the right side doesn't show any other discoloration. The lividity on Ms. Nicole was on the left side, not on the right side. These are distinct areas of discoloration consistent with bruising, in my opinion.
That's your opinion?
Yes.
Okay. Would you agree that as a medical examiner and expert in forensic pathology, that the only true way to distinguish the difference in such a case would have been to incise the area of the skin to see if hemorrhage was present.
That is correct. If I was doing the autopsy, that should have been done. But this is an injury, as you recall, was not observed by Dr. Golden when he did the autopsy. And this was reviewed by me on the photographs. And also our dental consultant had seen the same injury when he reviewed the photographs. He even considered it as for evaluation of his bite mark. And in my opinion, based on the distribution, the localization, the patchiness, and the presence of lividity on the other side, and the lack of any other discoloration on the rest of the body on the right side, I have no doubt in my mind that is an area of non-specific blunt force injury with patterned, mottled contusion ecchymosis. It's not lividity, that's contusion on the right back.
But you would agree that to correctly make this evaluation from a forensic pathology point of view, that you would have to do an incision?
If
It was asked but not answered.
Objection to counsel.
Sustain, rephrase the question.
Isn't it true that for a forensic pathologist to give a medical opinion, you would have to do an incision?
If you have a question, whether it's lividity or contusion, or you feel it necessary to prove it's a contusion, you need to make an incision. And usually we make an incision to see the depth of hemorrhage so that you can have an idea about the blunt force.
That wasn't done in this case, was it?
Yes, I already said that. This was an injury which was not observed, and it was not addressed till I reviewed the photographs and we addressed it. And I have already discussed that in my direct testimony.
Also, if microscopic slides were taken of this area, that would have enabled a forensic pathologist, expert medical examiner to distinguish a bruise or contusion from an area of lividity. Isn't that correct, sir?
If you can't make the diagnosis initially, I think I've already opined that once you do microscopic sections only if you need to date an injury. The injury diagnosis is made on gross exam. Sectioning the skin, I agree, would confirm your gross means visual impression, and microscopic exam is done only to date the injury.
Is it true, sir, that trace evidence should be removed and thoroughly looked for on the hands before the hands are fingerprinted?
Yes,
Was that done in this case?
yes,
How do you know?
because Ms. Claudine Ratcliffe and I discussed it. I asked her what was exactly done, and she told me that, and that's our normal procedure. You take all the evidence before you do fingerprinting.
Have you seen photographs of the hand with fingerprint powder on them showing that the fingernails had already been clipped?
I've not seen any photographs where that is.
Do you know if photographs were taken of the fingers before the fingernails were clipped and the body's fingerprinted?
No, the photographic process usually takes place in our office after the evidence is collected, because during the photographic process you wash the body. So all evidence in our office is collected before photography for the autopsy purposes. So the evidence was collected when the bodies came in on June 13th.
Isn't it true that during the course of fingerprinting that valuable trace evidence could be lost?
But I told you the evidence is collected before the fingerprints. But in your hypothetical situation, if fingerprints are done before the evidence is collected, then there's a possibility that you will contaminate the trace evidence.
You testified that it's the province of the coroner's office to notify the next of kin. Is that correct?
Yes.
That wasn't done by the coroner's office in this case, was it?
On one of the victims, we notified the next of kin, I think, and in the other person, I think Detective Lang notified the next of kin. I'm a little confused on which one we did, but one was informed by the police. So the police agency can notify the next of kin on our behalf. but
You-
it is a function of our office.
You have testified that there was a lot of blood lost by both victims in this case,
I said significant blood loss, yes.
and that the carotid artery, when severed, results in blood actually pumping out.
Yes.
Would you expect the perpetrator or perpetrators, if they were wearing gloves, to have those gloves soaked in blood?
There could be some blood contamination on the glove when the incision of the neck was made, if you're referring to Ms. Brown Simpson.
Would you expect the perpetrator or perpetrators to have a significant amount of blood on them?
Not from the last wound which I discussed, where the perpetrator was in the back and the neck was cut from left to right with the head being tilted. In that position, the perpetrator will not have much blood on the person because he's behind the victim. But the possibility of some contamination of the glove, I can't exclude because the hand is in front of the neck. And after all, the incision is going from left to right. So the bleeding from the initial vessel, which is cut, may contaminate the glove. But I will be surprised if the perpetrator in that situation would get any blood contamination on that person.
What about on the contact with Mr. Goldman, if they were face to face, as you opined at some point in time during this dynamic encounter they were? Would you expect the perpetrator to have blood?
In Goldman's case, the neck injury was a jugular vein injury. There would be blood, which will be, and also from the right neck injury, there would be blood loss, and there could be some contamination on the perpetrator. But the abdominal and chest wounds, the bleeding will be mostly internal, so you do not necessarily have blood on the perpetrator. And I also would like to emphasize that the jugular vein injury won't spurt blood like the carotid injury, which we discussed earlier.
Isn't it true that decedents continue to bleed after death?
Well, you'll have some oozing of blood from the remaining blood in the cut end of the vessel, but you won't have any pumping of blood because there's no blood pressure. So there could be some leakage of the residual blood in that vessel lumen. It's just like you have a garden hose, you turn the water off, still there's some water coming out of the tube, even though the water has been turned off, whatever water is left in the tube. So you won't have any active bleeding, you won't have any bleeding into the tissues, but there could be some residual leakage of an existing remaining blood in the lumen, but that's usually that's very minimal, if at all there is some.
You have no way of knowing, regarding Nicole Brown Simpson, what position her neck went in after it was cut, do you?
Excuse me, Your Honor, it's vague since she has multiple wounds to the neck.
Regarding any of the wounds to her neck, do you know what position her neck went in after injuries to her neck?
After the injury, she was left in the prone position. So I really can't tell you which position the neck was left in after it was cut. But since she could have died very rapidly after the injury, it could be the same position she was found in.
And it could not.
It may have been in a different position, but still she would have had to be prone with a face down position because all the blood flow is on the floor and there's nothing on her feet.
And you don't know if the body twisted at all, do you?
No, I don't know that.
And nobody knows that, do they?
That's correct.
And you don't know if the killer or killers were large, strong people, do you?
It's difficult to tell the size of a assailant, but given my opinion on Mr. Goldman's, where you have parallel cuts to the neck, the perpetrator must have been at least as tall or taller to get those parallel cuts because obviously Mr. Goldman was immobilized and there were parallel cuts to the neck. It'll be difficult for a perpetrator of smaller size to inflict those parallel cuts to the neck. It'll be difficult. I'm just saying it will be.
Are you saying a small person couldn't hold a knife up and make parallel?
So I would, based on that, I said I would favor the perpetrator to be at least of larger size or equal size of Mr. Goldman to immobilize him when this took place.
Well, based on the evidence that your office has presented, then you would opine that the perpetrator was at least 5'9" and weighed 170 pounds.
Well, that's what I said. I mean, that's what the weight is in the chart, and at least you must be equal size or more to really immobilize somebody. But it would be preferable for somebody to be larger size to really immobilize a person, because, as you know, in general terms, a stronger person finds it easier to immobilize a smaller person than people of equal size.
What about a smaller person who is very agile and quick and strong?
Well, as I said, the stab wounds could have been, for that is a possibility, but not for these control cuts. I would favor what I already said.
Have you ever seen small people beat big people? In fights?
Well, it's been reported there are smaller people who are more well-trained in martial arts than bigger people. So, yes, they can beat big people.
Regarding the stomach contents that were saved of Ronald Goldman, you were relying on the findings that you observed or that Dr. Golden observed regarding what those stomach contents contained?
I observed the stomach contents on June 22nd when we looked at the jar, but we didn't open it, but mainly on Golden's stomach content report.
You had an opportunity to look at it yourself?
Yes.
Is this something that you wanted to review and check to see if Dr. Golden was accurate in his description?
I did not do it independently.
Is this something that should have been done by you independently if you were reviewing Dr. Golden's autopsy protocol?
Well, I didn't see the necessity to do it because describing a stomach contents, and furthermore, it was only some spinach pieces and liquid. I didn't do it independently, any further studies on it.
Well, what if he was wrong about what the stomach contents are? And wouldn't that have some effect as to where he had his last meal?
Well, it doesn't have any bearing on the cause and manner of death or the injuries, which I have described already.
What about the time of death? His stomach contents were different than that described by Dr. Golden. Would that have any effect on the time of death?
I already opined on the time of death yesterday. It's such a variable factor. It's only an estimated range.
Now, what if somebody says that when he left Mezzaluna restaurant, he had nothing, he ate only spinach, and that stomach contents reveal residue from ice cream?
Objection.
Would that have any effect?
Objection has a effect
Oh, well,
And I'd like to refer to my notes because I remember seeing the contents. I can refer it, and then I could like to defer that question for a little bit because I do recall seeing the contents, but I'd like to refer my report before I say anything further on this question.
are you saying now that you have you don't remember what the stomach contents were of Ronald Goldman?
Well, I recall that they appear to be the same what was described by Dr. Golden, but I would like to refresh my memory before I answer this question further.
How long will it take you to do that?
Short time, I can look at my report.
It's up to Your Honor.
Be my guest. And may I see Mr. Shapiro and Mr. Kelberg for this moment, please? Hold on. All right, let's allow the doctor to find the place in his notes and refresh his recollection.
Okay. I examined the stomach bottle during the time we examined Dr. Barden. My notes are here. The stomach shows fragments of green leafy material, thick mucoid chyme material, masticated. So my notes reflect that I did see the contents, and so my recollection is that the contents described by Dr. Golden is accurate.
Spinach.
These are the original notes we took during the process. So that's why I pulled the original notes. That's why
So
I wanted
now-
to get it.
Are you done? I'm sorry.
I'm done.
So your notes confirm what Dr. Golden put into the protocol, that there was spinach.
Yes.
That was the only thing observable in the stomach contents of Ronald Goldman.
Yes.
Your Honor, I have a series of photographs that I have shown to counsel. I'd like to mark them 1194A.
All right, defense 1194A.
through J.
A through J.
May I approach the witness, Your Honor?
You may.
Dr. Golden. Dr. Lakshmanan, are those look at 1194A. Do you recognize that as a container that's used in your department?
Yes. This is a container from our department.
Now, I'd like you to go through the next series of photographs and describe what you see. The next one being B, I believe, is the contents taken outside the container. Would you describe what 1194B is?
This looks like some pasty, brownish material with some greenish leafy fragments seen in it on gross examination of this photograph. This is 1194A.
That looks like stomach contents containing spinach?
Well, it's not like looking at it directly as we did on June 22nd, but it could be interpreted as such. But I would not like to interpret it from the photograph, but from my previous knowledge, yes.
So your previous knowledge in this case is better than the photographs?
Yes.
Would you go through the remaining photographs and describe what they show? And I think just out of respect that these are probably not properly placed either on the Elmo or to the jury.
I would like to know what this particular photograph is. I can't.
Does that look like tomato peel?
Excuse me. First of all, I'd ask that the witness speak up.
Yes.
Mr. Shapiro, allow the witness to answer, and I'm not sure which photograph it is. The
Yes, doctor. Yes, I agree, Ms. Gelman. Doctor, would you tell us which photograph you're looking at?
I'm looking at now D, which shows a close-up of the same contents. And there's some low-power photographs of some material which has been separated off from the contents.
Doctor, which photograph is that?
This is 3 and E and F.
Can you
And
describe further what appears to be separated in those?
yeah,
You see food particles.
yeah, this looks like vegetable matter to me. And there's a close-up of the vegetable matter in I think this is G, Your Honor. G. And there's a close-up of another vegetable matter, which looks like a hedge. And there's also some two close-up photographs of another vegetable matter here, which is I. And this one is
Boy, you got me.
C. Probably C. Okay, C. These two, I can't really understand as well as these fragments here. So I'll
Right,
comment on
Doc.
these first.
The two that you just picked up and put down so that you can't tell what they are. What are the numbers on? What are the letters on the
This
back?
is C and B. On one of them, there's a fragment of what is seen on H. But these two look like two non-distinct brownish material, which I'm having difficulty understanding what it is. But these close-up photographs of I, C, and H, I can try and comment on.
All right. Would you say that these are a series of photographs that would show the process that a forensic pathologist would undertake to determine stomach contents?
Yes.
First, you would see it in a container, then you would empty the container out, then you would spread the material out.
Yes.
Then upon spreading the material out, you would try to separate from there any undigested or partially digested material.
That is correct.
Then you would take close-ups of those materials and try to compare them to other samples you've seen in the past.
Yes.
And now by doing that process, would you say that you would be able to see if, did you do that?
No, I didn't do that. I told you my only visualization of the stomach contents was on June 22nd, and I already described what we saw then. I didn't do this detailed study which has been done here.
Is that a proper way to do it?
That is correct.
And in doing it the proper way, do you see any evidence of raisins?
The three photographs where I can clearly identify, because, you know, the other photographs have a distant type of, it's not a close-up, so it's difficult to really define what it is. But these three close-ups show what is being photographed very clearly, and I can comment on these if you want.
Do you see any evidence of raisins? Yes or no?
Not in the photographs I see here, the ones which I said I could.
It's fine. Do you see any evidence of tomato skin?
Yes.
Do you see any evidence of green pepper?
I don't know whether I can call it green pepper from a photograph, but there's a fragment which could represent green pepper fragment, but I can't tell whether it's a green pepper or not.
Do you see any evidence of onion fragment?
Not from the distant photograph. I'm not able to tell whether it's there or not.
Are you familiar with a vegetable named kale?
No.
Do you see any evidence of spinach?
There is a leafy fragment here which could be spinach. And gross examination did show there was spinach.
By those photographs, are you testifying to a reasonable degree of medical certainty that that vegetable you see is spinach?
It could be spinach. And from my gross examination, it would favor being spinach, but it's difficult to say more than that at this point.
Are you medically certain it's spinach?
It looks like spinach, I said.
Well, don't you have a term that you use within a reasonable degree of medical certainty?
Yes.
And that's what an expert would say, right?
Yes.
A layperson would say it looks like.
Well, when you see a photograph of a vegetable fragment, and especially it's only a portion of a leafy fragment, there could be other leafy vegetables which can look the same appearance. So you won't be able to pinpoint exactly just from a cut fragment here. So I said it looks like.
Can you tell us within a reasonable degree of medical certainty, yes or no?
As I told you, from the initial examination of the stomach contents, it looked like spinach, and this photograph would be consistent with that diagnosis.
Well, would you say then that if these are in fact are the contents of Ronald Goldman, that the contents of the stomach, that many of the areas of food that was present were simply missed by you and Dr. Golden?
Could you repeat it again, please, your question?
If in fact these are photographs of the stomach contents of Ronald Goldman, which you still have, is that correct?
Yes.
Would you say that by offering your opinion that there was only spinach, that you made a mistake?
From the contents, yes, what was identifiable grossly, that's what, so it's not a mistake in the sense that from the initial impression, because no detailed study was done as it was done in this particular instance, as you showed in the photographs. So that way it's a mistake, yes.
You previously testified that you asked Dr. Golden to make an estimate as to the time of death.
Yes, I did.
And that's the most frequently asked question by homicide investigators in a case where there are no eyewitnesses, isn't it?
Yes.
And Dr. Golden responded that he advised you based on...
Objection, Your Honor, it's calling for hearsay for lack of foundation.
What's the nature of this? What's the source of the statement?
testimony of Dr. Golden under oath, page 12, lines 26 through 28 of the preliminary hearing.
Oral.
And Dr. Golden told you, based on the gastric contents, that death, quote, was somewhere 3 to 4 hours after her last meal.
Excuse me, Your Honor, that misstates the testimony with respect to telling Dr. Lakshmana, because the answer doesn't respond to the question.
Rephrase the question.
Did Dr. Golden testify in your review of the preliminary hearing on page 12, line 26 through 28? I'll give it to you. Do you need it?
Yes, please. As I told you yesterday, it's good to refresh one's memory. Page 28, sir.
On page 12, line 26 through 28, did Dr. Golden testify that based on the gastric contents...
Hold on, let him get the page.
Yes, I got the page and the line. Go ahead.
26.
Yes, I got it, sir.
Did he testify as follows, quote, based on the gastric contents of death, quote, was somewhere 3 to 4 hours after her last meal, end quote. Was that his testimony?
Yes.
And you gave testimony that her last meal on direct examination was between 8 and 8:15. Is that correct?
Well, that is my understanding based on the opening and closing of the bill which was presented to me.
Based on that, Dr. Goldman would place the time of death of Nicole Simpson between 11 o'clock and 12:30.
Excuse me, Your Honor,
Or
I'm going to object. It's taking out of context. Counsel can look at page 16, a specific question asked by Mr. Shapiro as to opinion as to the time of her death.
Sustain.
Your Honor, I can't ask this question based on, he went through for 2 days.
I understand. Both of you. Sustain the objection, rephrase the question.
Thank you very much, Your Honor. Assuming, based on Dr. Golden's expertise, that she died 3 to 4 hours after her last meal, and her last meal was between 8 and 8:30, what would the time of death of Nicole Simpson be?
Based on his testimony, it would reflect 11 to 12:30 based on his testimony and his opinion.
Didn't Dr. Golden further testify on page 13, line 16, that on the basis of rigor mortis, the time of death was between 9 and 12 hours prior to 10:50 a.m. when it was measured?
I'm sorry.
13.
That just states the testimony.
Why don't you read it?
Mr. Shapiro.
I'm going to refer you to page 13, line 16. All right, you with me?
Yes, sir, I'm following you.
And then I considered the rigor mortis determination, which at the time the investigator performed her determination, the body was in full rigor. If now I may pick up and look at page 1 of the coroner's protocol, the rigor was fixed and was fully fixed. So that also placed the time of death somewhere beyond 9 to 12 hours. And assume that the investigator concluded that rigor was fully fixed at 10:50. What would the estimate be as to the time of death of Nicole Simpson?
Based on his testimony and based on the information he's used, the calculation for that would be that death occurred before 10:50 p.m. It says beyond 9 to 12 hours. If you take 9 hours, it occurred before 1:50 a.m. If you take 12 hours, it occurred before 10:50 p.m. of June 13th.
Doctor, doesn't that conclude that if it's between 9 and 12 hours prior to 10:50, it would be between 10:50 p.m. and 1:50 a.m.?
No.
The objection states the testimony that leads up to
It doesn't state that. It says beyond 9 to 12 hours. That means the death occurred before. If you use a 9-hour number, it means death occurred before 1:50 a.m. If you use the 12-hour number, it means death occurred before 10:50 p.m., which means death occurred before that. Because as I told you yesterday in rigor mortis, once it develops, you can't tell how long it's there till it passes away. So that's what this testimony is. So he says in this testimony, death occurred before 1:50 a.m. And if you use a 12-hour statement for fully developed, it occurred before 10:50 p.m.
What's 9 hours prior to 10:50 a.m.?
1:50 a.m.
What's 12 hours prior to 9:50 a.m.? Prior to 10:50 a.m.?
10:50 p.m. of the previous day.
Thank you. Nothing further.
Kelberg?
Doctor, let me read you the testimony if I could, and then do some very quick calculations. Oh, first of all, no, let me invite counsel to page 16, lines 3 through 7, and ask if you reviewed this testimony as well, Doctor. Question by Mr. Shapiro at the preliminary hearing. Do you have an opinion as to the time of death of Nicole Simpson? Answer by Dr. Golden, I can give you a range. Question, and what is that range? Answer, somewhere between 9 o'clock and midnight. Recall that, Doctor?
Would it tell me the page number again?
16.
Yes.
Lines 3 through 7, questioning by Mr. Shapiro. Recall that?
Yes.
Is that consistent with your own opinion?
Yes.
Now, with respect to the question that Mr. Shapiro asked just when he stopped his examination, the answer given by Dr. Golden at the preliminary hearing stated, starting at line 20, the rigor mortis was fixed and was fully fixed. So that also placed the time of death somewhere beyond 9 to 12 hours. Doctor, assuming that the rigor mortis reading was obtained at 10:50 in the morning, and the assessment is that that shows death was beyond 12 hours before that time, then what is the latest time that the death could have occurred according to that opinion by Dr. Golden?
That means the death occurred beyond 12 hours. That is, death occurred before 10:50 p.m.
And according to that, then the latest time for Nicole Brown Simpson's death would have been 10:50 p.m., correct?
No, it is.
The latest time.
That's correct.
And she could have died, according to that opinion of Dr. Golden, earlier than 10:50, including 10:15, correct?
That's correct. That's what I testified to.
And Doctor, going back to the gastric contents question asked by Mr. Shapiro, where Dr. Golden said, my estimate was based on the state of the gastric contents and the character of the gastric contents. It was somewhere 3 to 4 hours after her last meal. If Dr. Golden misspoke and left out the word within, so that his answer that he intended was actually it was somewhere within 3 to 4 hours after her last meal, would that be consistent, in your opinion, with the usefulness of the stomach contents as an estimator of time of death?
Sustained.
Assuming hypothetically, doctor, well, let me withdraw the question. Doctor, number one, in your opinion, would it make medical sense, based upon the observation of the stomach contents, to place the time of death at 3 to 4 hours after her last meal?
As I testified yesterday, you need to see grossly identifiable fragments, and that would suggest the meal was taken 2 hours prior to death. But as I said, because of the various variabilities, it's difficult to give an exact estimate.
And one of the studies you relied upon, the Bolandi study, which used pasta like rigatoni as the meal that was being followed in the stomach and through into the intestines, indicated that in normal, average, healthy people, the passage time was 4 hours for the entire contents to pass the stomach, plus or minus 30 minutes, right?
Yes.
And in the observation of Dr. Golden, there is still 500 cc's, 3 ladles of 6 ounces each, of identifiable rigatoni in Nicole Brown Simpson's stomach. Is that correct?
Yes.
And if that is the case, doctor, that it takes 4 hours for the stomach to empty, and on the other hand, you find 500 cc's of rigatoni-based contents in the stomach, does it make medical sense to say that the person died 3 to 4 hours after having eaten that meal?
No, because they could have died within 3 to 4 hours, because as you know from that, if you're using that study as in your hypothetical, stomach would have emptied in 4 hours, and you still have a lot of residual material in the stomach, so it would be within 4 hours rather than 3 to 4 hours.
And doctor, if Dr. Golden's opinion regarding the actual time of death, as he told Mr. Shapiro in response to his question, was somewhere between 9 o'clock and midnight, would an opinion saying that death was 3 to 4 hours after the meal and the meal was ended somewhere between 8 and 8:30 be consistent with what Dr. Golden has said is his opinion, 9 o'clock to midnight?
Yes.
Now, doctor, let me ask you briefly, and let's see if maybe we can get you out of here by noon. Just a few questions. First of all, if Mr. Shapiro feels that there's any value to Dr. Golden's testimony beyond what you've already said, is Dr. Golden available at your office at any time to be called by Mr. Shapiro to this courtroom and examined as a witness by Mr. Shapiro?
Overruled.
You may answer the question, doctor.
To my knowledge, he's available.
And if I ask you to make sure he's available, will you do your utmost so that if Mr. Shapiro wants him here, all Mr. Shapiro has to do is let me know, I'll let you know, and Dr. Golden will be here?
I'll do my best to make that happen.
Now, a couple other points, doctor. You were talking about why you believe the killer would have been at least the size of, if not bigger than, Mr. Goldman. You recall that series of questions that Mr. Shapiro was asking?
Yes.
Doctor, did you have provided to you some information concerning shoe sizes and human stature, that is heights and weights of people?
Overruled.
I,
Overruled. You
I-
can answer the question.
I briefly reviewed that material.
Doctor, I want you to assume that there were bloody shoe prints found along the walkway leading from the bodies to the back of the Bundy location, and that I want you to assume, hypothetically, that there will be testimony that those bloody shoe prints are consistent with a person who has a size 12 shoe. And I want you to further assume, hypothetically, that people who wear size 12 shoes tend to be 6 feet to 6 feet 4, based upon studies conducted by the Royal Canadian Mounted Police and the FBI. Doctor, would that type of evidence, assuming it is true, serve to confirm your opinion that a single killer of a height greater than Mr. Goldman, in a swift and violent assault on both of these human beings, is the perpetrator?
Objection to reapproach.
No. Overruled.
I already said it could be such a kind of perpetrator.
And Mr. Shapiro asked you, would you stake your reputation to a reasonable medical certainty? Remember that question?
Yes.
Doctor, would you stake your reputation that based upon the forensic pathology evidence you reviewed, that all of that evidence is in fact consistent with one killer, 6'2", 210 pounds, athletically built, with the element of surprise, with a 6-inch long, single-edged knife, killing Nicole Brown Simpson and Ronald Goldman? Would you risk your reputation, stake your reputation on that?
I said one person could have done all the injuries. Yes, I did say that.
And will you stake your reputation that all of the evidence is consistent with that?
Yes.
Now, doctor, this driver's license, 85A. Have you known people to fudge a little bit on providing information to the Department of Motor Vehicles with respect to heights, weights, ages, and so forth?
Objection calls for speculation.
Sustain. I think it's beyond the scope of this particular.
All right. Doctor, have you ever encountered people who feel it's important to be 6 feet tall, even if they might be like 5'11" or 5'10"?
Objection irrelevant.
Sustain.
Doctor, Mr. Shapiro asked you something about glancing blows. Recall that testimony this
Yes.
morning?
Yes.
And he talked about the possibility of one knuckle striking the chin. Recall that?
Yes.
Now, by definition, would you opine that a glancing blow results in the transfer of less force by the very nature of being a glancing blow?
As I already said, that in a glancing blow, the energy is not delivered completely to the target. Only a portion of the energy is delivered.
And if that is in fact the situation, doctor, does that reduce the likelihood that you would expect any injury to be seen on the person receiving this glancing blow
That would be a logical conclusion.
and on the person delivering the glancing blow?
That would also be a logical conclusion.
And doctor, there was questioning by Mr. Shapiro about would you expect somebody to kick and do all these various things to try and survive? You recall that series of questions?
Yes.
Doctor, if somebody has a human being from behind and has a knife at their throat, would you expect the first place that that victim is going to try and deal with to be the knife, which is the immediate threat to the person's life?
That would be an expected reaction.
And if the knife is at the throat, would you expect the person to be trying to kick the perpetrator where the knife is?
That I would not be able to state whether it could happen or cannot happen, because it depends on the fear element in the victim. Because as I told you, the victim could be in fear and frozen, and there could be no kicking and nothing. But so the reaction for that kind of hypothetical is difficult to speculate, and I would not wish to make any further statements on that.
Doctor, when you talk about freezing, in fact, is it a recognized phenomena even in wartime that men and women who are being shot at or threatened with immediate death, some of them literally freeze and are unable to move?
Objection, speculation beyond his expertise. Unless he's participating in the war and so on.
I should rephrase the question.
Doctor, from your knowledge as a physician, are you aware of such information that indicates that in circumstances where people's lives are in fact immediately threatened, some people simply freeze, unable to move?
I've heard of such information, yes.
Now, doctor, you testified also, Mr. Goldman has no cuts to the back of his hands, right?
Yes.
And he has defensive wounds as if trying to ward off with open hands a knife, correct?
That is my statement, yes.
And all of that, doctor, is inconsistent with the fist of Mr. Goldman being created, that is, by the hand closing.
That was my opinion also. It's unlikely, I said.
Just a few more questions, if I might, Your Honor. Mr. Shapiro asked you something about the aging of contusions and abrasions. Recall that?
Yes.
And wouldn't microscopic slides be helpful?
Yes.
Are we talking about aging in the sense of, is it antemortem, perimortem, or postmortem? Or are we talking about aging in determining time of death?
Aging is for the age of the injury. You cannot estimate the time of death from the injury itself.
And doctor, since Mr. Shapiro asked about contusions versus lividity, remember that photograph B9?
Yes.
The area where you said there was a nonspecific blunt force trauma, if that had been an area of lividity, can you explain how it would exist in that area given the position of the body which had the dependent portion of the body, that is the body that is below, being the left side, not the right side?
It was on the right side, and Nicole's lividity was on the left side.
And can you then explain how being on the right side, that bruised area, how that could be lividity? Scientifically, is that possible?
That's why I said it's not lividity, and there was no other discoloration on the right side of the body.
Do you have to make any kind of incision, given the evidence that you had, to understand that situation?
No, but during the autopsy, if a doctor has a doubt, there is always an available option to make an incision to confirm your initial impression.
Now, doctor, just a couple more questions. Who sets the cost for these slides?
Our department accountant, in consultation with the auditor, they figure out what are the processes involved, salaries involved, time element involved, and they come up with some mathematical calculations, and the county has its way of getting the numbers which involves in the cost recovery.
Are you involved in that calculation process at all?
No, sir.
Lastly, doctor, were you graded by Mr. Tuno on his suggestion that you learn to talk louder in court?
He didn't tell me to talk louder, but he gave that as a general advice to everybody, that to speak up and express yourself. That was general advice given during the talk.
And if you see him again, I suggest he might ask you to speak louder, like if you're another witness in another case. With that, Your Honor, I have.
Mr. Shapiro? Certainly. right, ladies and gentlemen, we're going to take our noon recess at this time. Please remember all of my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't allow anybody to communicate with you. Do not conduct any deliberations till the matter has been submitted to you. We will be in recess until 1:30, so a little longer lunch hour today. And Doctor, 1:30.
Yes.
Thank you. All right, back on the record in the Simpson matter. The defendant's again present before the court with his counsel. People are represented. Jury is not present. Good afternoon, Mr. Shapiro. You had something you wanted to comment on?
Your Honor, yes, we
Bring to
would
the
like
court's attention.
to address the court regarding evidence that we would like to present before the jury regarding findings of Judge Pounders in 2 homicide cases that were autopsied by Dr. Golden, and where the cause of death in both cases had been changed after the defense brought in their expert witnesses.
The cause of death was changed?
Not the cause, I'm sorry. The type, the circumstances surrounding the death. One, there was an exit wound versus an entrance wound that was later changed, and one was also the distance at which a weapon was fired. Both of those cases were capital murder cases against one defendant as a result of the change in the findings by Dr. Golden, as well as the lack of a witness. Those cases were dismissed, and Judge Pounders made a finding of factual innocence. We would like to bring that to the jury's attention.
In what manner?
By simply asking this witness, by simply asking Dr. Lakshmanan, are you aware that as a result of the mistakes that were made by Dr. Golden in these 2 autopsies, that these cases resulted in somebody who was being prosecuted for capital murder having the charges dismissed on the motion of the district attorney?
And what's the basis of this information? I mean, do you have the certified court documents available?
Yes. I actually have the district attorney's file, the internal memorandums from the district attorney who handled the case to Mr. Sunstead, who was the person who made the approval.
No, but my question is, I mean, the district attorney's file is oftentimes an interesting source of information, but it's not the official court record.
The official court record has been destroyed based on a finding of factual innocence.
No, but that record would still exist.
Well, I was told by the attorney who filed the petition that the record doesn't. We tried to find it. The DAs tried to find it yesterday. They couldn't. The only record they had was their file, and the only record that the coroner has there are 2 autopsy reports.
Mr. Kelberg?
Your Honor, so that the record is complete, Mr. Shapiro had the opportunity both to peruse our file and speak at length with Mr. Grace, who was the prosecutor of the case. Obviously, this questioning, in my judgment, A, calls for hearsay, lack of foundation as to what Judge Pounders did or did not do. B, is completely irrelevant. The issue is, were the mistakes of Dr. Golden, which are relevant only as to his competency, mistakes which are significant from a medical perspective. Dr. Lakshmanan is no better qualified to talk about the legal significance than would be the ordinary layperson. Dr. Lakshmanan is a forensic pathologist. He is not a lawyer. The third item is, just so that the record is correct, there has been no contact between Mr. Grace and Dr. Lakshmanan, or really any other person in the coroner's office regarding any mistakes by Dr. Golden in these 2 cases, the Gay Phillips cases. And that what Mr. Shapiro said on the record he was led to believe existed simply is not the case. There is no such communication. Dr. Lakshmanan knew nothing more about this until this matter was raised as part of the Primetime Live materials and the Framolino letter from a reporter with the Los Angeles Times. in fact, what the district attorney's office file reflects, and what was confirmed by Mr. Grace, is that our office moved to dismiss the charges based in part on Dr. Golden's change of opinion. And the memorandum does not talk about mistakes, just change of opinion. And that change of opinion contradicted the testimony of an eyewitness who was the primary witness on which the prosecution was based. And compounding the change in circumstances that situation created, that eyewitness was apparently not able to be located. So as a result of that combination of circumstances, a recommendation was made to have the charges dismissed, and that recommendation was approved by the appropriate chain of command in our office. And what happened from that point on, obviously it was dismissed, and Mr. Grace is in a position to say it was dismissed, but there's certainly no recordation that I reviewed from a minute order or a transcript to reflect the circumstances when I assume Mr. Grace moved the court formally for a motion to dismiss.
Are you aware of any authority to destroy a court file after a finding of factual innocence?
Your Honor, I am not aware that the court would destroy any file on such a finding. I believe it in the penal code dealing with sealing of records on findings of factual innocence is probably what Mr. Shapiro is talking about in order to protect the person who had been accused from having to disclose or have available to outside review these materials. But I am not aware of any statute which would either authorize or approve the court destroying the court's file on the basis of a determination of factual innocence.
So what's the legal basis of your objection?
Legal bases of my objection are multifold. Number one, it calls for hearsay, lack of foundation. If Judge Pounders said something and did something, it's got to be from Judge Pounders' mouth or from some admissible document that qualifies as an official record. As the court is well aware, judicial notice may not be taken of everything that is in a court file, and that in fact many of the matters that are within a court file are subject to the same hearsay exceptions like official records. But you've got to be able to lay a foundation, and obviously there is no such record here, even if the court was being asked to take judicial notice. So hearsay, number one. Number two, it's irrelevant. It is irrelevant to the issue of whether Dr. Golden is a competent forensic pathologist or not. What is relevant, as the court found, is did he make mistakes that reflected on his skills as a medical examiner? And secondly, if he did make mistakes, are those mistakes of medical significance? Because if they are significant medical mistakes, then it clearly goes more to demonstrate a lack of competency than if they are insignificant mistakes, which have really no reflection upon his skill. Dr. Lakshmanan is eminently qualified to evaluate the medical significance of any such mistake, but he is not a lawyer. He is not a judge. He is not a qualified expert witness on the subject of the legal significance, and he would be unable to know the legal significance because it was Mr. Grace and the people in our office who at least initially made a determination to move to dismiss. The record, at least in our file, is clear that the basis for that motion is not either exclusively on the grounds of Dr. Golden's mistakes or necessarily on the grounds that they are mistakes. It is on the grounds that the evidence produced by the amended opinion reflects inconsistency between that opinion and the eyewitness account, which makes the case problematic, followed by the unavailability of the witness, even if one wanted to believe the credibility of the witness over Dr. Golden's amended opinion. As a result of which all of this is speculative, 352, irrelevant, outside the scope of expertise of Dr. Lakshmanan, calling for hearsay, lack of foundation.
Mr. Shapiro, any response?
Thank you.
I'm concerned about the foundation for this matter.
Foundation, we can get in by doing what I would prefer not to do and hopefully do by stipulation, since there are no facts in dispute, by calling Mr. Grace, who in fact was the prosecutor in the case. The real issue is so that this jury is not confused and misled. Dr. Lakshmanan continued under questions from the prosecutor to say that none of these things affect what he refers to as big ticket items. Nothing affects the cause of death or the manner of death. What we want to demonstrate, and therefore it doesn't affect the competency of Dr. Golden. What we want to demonstrate to the jury is, even though the cause of death was not changed in two cases where Dr. Golden testified, they both died of gunshot wounds, and even though the death certificate was not changed because that was the same, the findings that he made, that is Dr. Golden as a forensic pathologist, changed the course of events for somebody who was prosecuted and caused, in part, somebody who had been in jail for 3 years to be released and a finding of factual innocence. If that is not a major item and a major piece of evidence for a forensic pathologist to have, there can be no bigger area for a forensic pathologist to examine. And that's what we want the jury to know. The prosecution has tried to narrow to a great degree certain issues and take away everything else that a forensic pathologist has to do and has to look for. And that if those opinions are incorrect, then the jury now is left with the idea, well, these, according to the prosecutor and Dr. Lakshmanan, are not important. Well, an exit wound and an entrance wound not only is important in making a correct analysis from the point of view of a medical examiner, it is essential when it comes to guilt or innocence. And he is making several similar opinions in this case, and he's relying in part on his opinions based on the work of Dr. Golden. And I think it's important for the jury to know how significant these errors really were.
All right. Mr. Shapiro, I think I have allowed wide latitude to the defense to cross-examine Dr. Lakshmanan regarding Dr. Golden's competence. I allowed going into these other cases where significant mistakes were made. I think, though, to ask these questions of Dr. Lakshmanan would be, one, asking him to come to a legal conclusion, which I don't believe he is competent to make. I think that we have a lack of foundation here for the legal conclusions. We don't have a court file. There's nothing I can take judicial notice of. And I think under 352, we also have a problem that there are too many other factors that Mr. Kelberg mentions that went into the decision to dismiss the case beyond just the issue of Dr. Golden having made a mistake as to the entry, exit, and the proximity. That issue has already been clearly presented without ambiguity to the jury that he's made those mistakes. And what the legal consequences are, the explanation for that will take more time than it's worth at this point. We've established the point that Dr. Golden made a mistake, so I'll sustain the objection.
Your Honor, just for the record, may I make an offer of proof that we could meet the foundation requirement?
Certainly.
And we could meet that very easily by calling the prosecutor in this case, who will substantiate what I have said, by calling Mr. Lindner, who was the defense attorney in this case, who will substantiate it. I have not talked to Judge Pounders, but because this case was so unusual, it is the opinion of both lawyers that he would recall this independently. So I think we could get over that foundational requirement and would present that to Your Honor. Second, just for the record, we would like to mark as exhibits to be part of the court file the letter from Charles Lindner to Robert Grace explaining the errors that were made, the summary and findings by Deputy District Attorney Robert Grace, and two district attorney forms, which are the disposition reports and the recommendation for dismissal. We'd like to incorporate these as a joint exhibit along with the protocols of the two decedents and autopsy reports for the record only.
Certainly. And we'll collectively, what is the next defense exhibit in 1195 with a clear designation not to go to the jury unless otherwise ordered?
Thank you very much, Your
All
Honor.
right, thank you.
Can I just inquire from Mr. Shapiro, who these are original?
No, those are copies.
Your copies? Do you stipulate that these are copies from your file?
Certainly.
All right, thank you, counsel. Anything else?
Not by this.
All right, and we're prepared to present the next witnesses after we've concluded with Dr. Lakshmanan.
Don't look at me, Your Honor.
Mr. Darden, good afternoon, sir.
Good afternoon, Your Honor. We're going to require a 15-minute break prior to the next set of witnesses.
Yeah, we have a lot of exhibits to move around and get out of the way. All right, I agree. All right, Deputy McNair, let's have the jurors, please. Department 110 needs your presence.
I haven't had the next one, Chair. Perhaps, I think this will be real quick. Can they give me 5?
Counsel, you have the court's leave to go. Would you tell Department 110 we go?
Only 12 minutes of redirect.
I'm just trying to accommodate counsel's other obligations. Let's proceed. On the representation, it's only 5 minutes.
Less than 5.
Less than 5 minutes. All right. All right, let's have the jurors. Got other cases. I've got other cases. You've got other cases. Dr. Lakshmanan, would you resume the witness stand? And Mr. Shapiro, you may continue with your cross-examination.
Thank you. Good afternoon, ladies and gentlemen. Good afternoon again, Dr. Lakshmanan. Thank you, Your Honor. Dr. Lakshmanan, I'd like to show you something on the Elmo, please. Can we put that up, Mr. Harris? Like to mark this defense next in order. What I'm going to show you is something referred to as the golden rule of homicide investigation. And I'd like to ask you the following question regarding the golden rule, which states never touch, change, or alter anything until identified, measured, and photographed. Remember that when a body or an article has been moved, it can never be restored to its original position. Do you agree with that rule, sir?
Yes.
Thank you. Nothing further.
I am done, Your Honor.
All right. Dr. Lakshmanan, you are now excused as a witness, sir, subject to recall. Thank you very much, Doctor.
Thank you, Your Honor.
All right, ladies and gentlemen, this concludes the presentation of the medical evidence by the prosecution. At this time, we are going to shift focus to another area. I'm going to have the attorneys clear out some of the exhibits so that we have more room, And so we're going to take a recess for about 15 minutes so we can bring those exhibits together. I'm sure you understand. All right, so we'll see you back here in about 15, 20 minutes. In the Simpson matter, Mr. Simpson is again present before the court with his counsel. People are represented. And I see we have Mr. Darden, Mr. Gordon, and Mr. Wooden with us today. All right, good afternoon, gentlemen. All right, Mr. Darden, are you going to present the next witness?
Yes, Your Honor.
Are you prepared to proceed? Yes. All right, Deputy McNair, may we have the jurors, please? All right, let the record reflect we've been rejoined by all the members of our jury panel. Mr. Darden, you may call the people's next witness.
Thank you, Your Honor. Good afternoon. Good afternoon. The people call Brenda Vimich to the stand, Your Honor.
All right, Ms. Bimich, would you come forward, please? Stand right next to the court reporter, please. Raise your right hand, face the clerk.
You do solemnly swear that the testimony you may give in the cause not pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God? Please have a seat and we can stand and state for your first and last names for the record.
Brenda Vemich.
Can you have your spelling, please?
V as in Victor, E-M-I-C-H.
Thank you.
Mr. Darden.
Thank you, Your Honor. Good afternoon, Ms. Vimich. Ms. Vimich, who are you employed by?
Bloomingdale's.
And what is your position with Bloomingdale's?
I'm a buyer for men's dress shirts.
Men's dress shirts?
Yes.
And were you employed by Bloomingdale's on December 18, 1990?
Yes.
And what was your position then?
I was the men's gloves buyer.
You were the men's glove buyer. During December of 1990, did Bloomingdale's have a relationship with Eris Isotoner?
Yes.
And did Bloomingdale's sell Eris Isotoner gloves?
Yes.
Can you tell us whether or not there was a line of gloves sold exclusively by Bloomingdale's, that is, gloves that were manufactured by Eris Isotoner?
Yes.
And can you tell us the name or the style of those gloves?
Well, we bought many gloves from Eris, but there was one particularly important glove, and it was called an Eris leather.
Sustain. Just raise the question, please.
Okay. Did Bloomingdale's sell more than one type of glove, that is, more than one exclusive type of Eris Isotoner glove?
Yes.
Are you familiar with the glove called Eris Isotoner Thin?
I don't understand the question.
Okay. Are you familiar with the glove that goes by the style number of 70263?
Yes, that is an Eris leather light glove that was an exclusive glove for Bloomingdale's.
And this Eris leather Eris leather light glove was manufactured by Eris Isotoner?
Yes.
Okay. And you were in charge of purchasing gloves for the men's section?
Yes.
Were you selling that particular type of glove on December 18, 1990?
Yes.
Okay. And in which department in the store could those gloves be purchased?
In the seasonal glove department, seasonal accessories.
And if you know, what was the retail price of those gloves?
Those particular gloves were $55.
And what was the selling price on December 18, 1990, if you know?
They were $55, but during December 18th, they were marked down at 30% off.
Could you describe style number 70263, the Eris Isotoner leather light glove?
Yes, this particular glove has many characteristics that are very distinctive to this type of glove. One of the first characteristics is the leather. The leather is extremely lightweight, almost paper thin, and that was one characteristic. The second was the stitching. The stitching of this glove was called a brosser stitch, which is a very refined whip stitch.
How do you spell that? Rosser.
I believe it's Brossier.
Thank you. Done.
So the stitching was very unique as well.
Okay. Any other unique characteristics?
Yes, the vent palm was on the palm side of the glove. The V that is in the glove is in the palm side. So that was another characteristic.
Okay. Now, was there a lining to these gloves?
Yes, they were cashmere lined. So all four of these characteristics combined together made this glove a very unique and special glove.
During the recess, you were here in court this afternoon, is that correct?
Yes,
And at that time, were you asked to view two gloves in particular?
yes,
By the way, have you ever visited any factories where gloves are manufactured?
yes, many times throughout my career in accessories.
And have you tried several pairs of gloves on?
Yes, many, many, many pair.
Okay, in your professional capacity? And that was in your professional capacity?
Yes.
I'd like to show you a pair of gloves that have already been marked.
Where would you like to do it, Mr. Darden? You want to do it here on the shelf in front of the witness?
Okay.
Mr. Wooden, do you want to just pull off a sheet of paper and fold it up to that side, please?
Ms. Vimich, given the description you provided us of the Eris Isotoner leather light already, are you able to identify that glove when you see it?
Yes.
Let me show you the glove that has been marked. People's 164A. It is LAPD item number 9, the Rockingham glove. Showing you People's 164A. Looking at that glove, can you tell us whether or not that glove is an Eris Isotoner leather light glove?
Can you turn it off? Yes, this is an Eris leather light glove.
Does this glove have the the V indentation in the palm area that you described earlier?
Yes, the vent palm.
Okay, how about the stitching?
The stitching is the Brosser stitching. The lining is cashmere.
And does the leather appear to be particularly light as you described earlier?
Very thin for a glove, yes.
And this glove, the glove exclusive to Bloomingdale's?
Yes.
You looked at these gloves during the recess. Was Mr. Cochran present?
Yes.
And Mr. Shapiro?
Yes.
Okay, and myself and Mr. Wooden?
Yes.
Show me the glove that has been marked Exhibit 77. The People 77.
Can I turn it, please? Yes, this is an Eris leather-like glove.
Ms. Fenich, if you know, how many pairs of these gloves did Bloomingdale's purchase during 1990?
Bloomingdale's purchased approximately 1,000 dozen, which would be about 12,000 pair.
And what is the color of the two gloves you just saw?
The color's brown.
And what is the size?
Size is extra large.
During 1990, how many pairs of Eris isotoner leather-like gloves, brown in color, size extra large, did Bloomingdale's purchase?
Approximately 300.
300 pair?
Yes.
Now, when you say that these gloves were exclusive to Bloomingdale's, what exactly does that mean?
That means that these gloves were designed and developed for only Bloomingdale's, and were sold nowhere else.
Have you ever seen these gloves sold anywhere else in the United States?
No, I have not. Not these gloves.
Okay. And have you traveled abroad to Europe and to Asia?
Yes.
Have you ever seen these gloves in Europe or Asia?
No, I have not.
Is there a Bloomingdale's in Los Angeles?
No, sir.
Where is the Bloomingdale's that is the one closest to Los Angeles?
The closest one, I believe, is in the North Michigan area, in the Chicago store. It's the closest.
The Chicago store is the closest?
Yes.
Now, did you purchase these same gloves for Bloomingdale's during 1991?
No, I did not. I inherited this particular buy, the first buy.
Okay. Were pairs or several pairs sold to Bloomingdale's during 1991?
Yes.
How about 1992?
Yes.
Okay. 93?
Yes.
You purchased the same gloves that I've just shown you or the same style during 1993?
The manufacturer started changing some of the...
Sustain. Mr. Darden, ask the question again, please.
Okay. At some point, did the manufacturer start to change the the style of glove that I've shown you here in court today?
Yes,
What year was that?
1993.
Okay. Did they change the style number in 1993?
No, they did not. They only changed the stitching.
Okay. And so the 1993 model of the Aris isotoner leather light, how is it different from the gloves, if at all, that are here in court today?
The stitching, the Brosser stitching was changed. They changed it to what is called a piqué stitch.
And the gloves I've shown you here in court today are not gloves having a K stitch.
No, that is a Brosser stitch.
Now, give me your position as a buyer for Bloomingdale's. Are you in a management position?
Yes,
And have you been trained in how to ring up credit card purchases?
I've been trained how to buy and merchandise and develop, and occasionally I sell the merchandise myself.
Okay, and so you have received cash register training then?
At one point in time, we have received training, but that is not my primary function. But it's important for me to be on the floor to see what we sold. So I spent a great deal of time waiting on customers and working with them. And specifically, one of the areas that I spend the most amount of time is in the glove area.
On December 18, 1990, was the merchandise in the men's department barcoded at all?
No,
Okay, so you couldn't just sweep it across the device and ring up the purchase automatically?
no.
How was information, that is the sales information, placed into the computer or sales register?
It was entered in manually.
You know, the next in order is People's 372.
People's 372.
I've shown Mr. Cochran a, you want to see the original? Copy of the next exhibit. It is entitled Bloomingdale's Glove Purchase.
All right.
On the Alma. This image, there is a monitor there to your right. Looking at the item marked People's 372 for identification, can you tell us what that item is? The item depicted there?
Well, this is a Bloomingdale's receipt,
Okay,
but it's a little bit blurred here.
okay. Now, I have a second item. It appears to be a microfiche copy of this same receipt. Can it be marked, what if you make a 372B and the item on the Alamo 372A?
All right. So, Mark.
Showing you what has been marked 372B. Is that a Bloomingdale's credit card sales receipt?
Yes,
And is that apparently a copy of what you see there on the monitor?
yes, it is.
Okay. Now, looking at that receipt, there are several numbers on it. Is that correct?
Yes,
Can you interpret those numbers for us?
yes.
Okay.
The 517 represents the department number seasonal accessories.
Okay. Let me stop you there. Okay, that's to the left of the sales receipt. Is that correct?
Yes,
Okay. 517 indicates men's accessories seasonal department.
yes,
Okay. Now, do you see the number 222034 at the top upper left?
yes.
Okay. What is that number?
That's the employee's ID number.
And whose employee ID number is that, if you know?
It's Helena Phibbs' employee's number.
Okay. And is Helena Phipps here in the courthouse this afternoon?
No, she's here, but not in this room.
Okay. She's in the building.
Courthouse, yes.
Okay. Thank you. Okay. And to go down to the right of the 517, we see the numbers 55.
Yes.
What do those numbers indicate?
That is the classification number, and 55 represents a glove classification.
So that indicates that gloves were purchased?
Yes.
Okay. And to the right of the 55 is the number 953.
Yes.
Okay. What does that number indicate?
That is the vendor number, and in this case, it is Eris isotoner.
And so based on those three numbers, then you can tell us that there was a purchase in the men's accessories department?
Seasonal.
Gloves were purchased,
Yes.
and that they were Eris gloves?
Yes.
And to the right of the 953, we see the number 70268. What is that number?
That is the style number of the glove.
Okay. And we'll come back to that. And to the right of the 70268, we see the number 2. What does that indicate?
Quantity that were purchased is two gloves.
2 pairs of Eris gloves?
Yes.
And to the right of the 2, we see the number $77.
Yes, that's the retail for the 2 pair of gloves.
Okay. And to the right of the $77, we see the number 30. Is that correct?
Yes, and that is 30% off.
So that means then the 2 pairs of gloves were purchased for 30% off at $77?
Yes.
Can you tell us what the regular price of the gloves?
The regular price of gloves of this style is $55.
How many pairs of gloves or types of gloves did you sell at $55 during December 1990?
From this vendor, Eris, there,
Oh, well. Go ahead.
She's holding the exhibit. She's holding the exhibit. Proceed. Mr. Beck.
How many different types of Eris gloves did you sell at $55 during
there was
December
only
90?
one Eris glove that I sold at $55.
And what style number was that?
70263.
And which glove is style number 70263?
Eris leather light glove.
So the gloves I showed you in court today then fit the descriptions given on this sales receipt?
Yes.
Okay. Now, the style number on the sales receipt indicates 70268. Is that correct?
Yes.
Did Bloomingdale's ever sell an Eris glove style number 70268?
No, they did not.
To borrow a phrase, is that a mistake?
Yes.
Does that mistake, we'll strike that. The mistake is that the 8 should have been a 3, is that right?
Yes, it is.
Sustained.
Okay, and what is, okay, thank you, Your Honor. What is the mistake?
The last digit should be a 3, not an 8.
Has Bloomingdale's ever purchased Eris glove style number 70268?
No.
Do you know whether or not Eris style number 70268 has ever been sold in the United States?
Not that I don't know.
Can I have one moment, Your Honor?
Sir.
Does the sales receipt indicate the size of the glove?
No, it does not.
Does it indicate the color of the glove?
No, it does not.
Is there any way for you to tell us that the 2 gloves I showed you here in court were purchased during the transaction shown here, People's 372A?
No.
Now, is there a date on that transaction record?
Yes, the date is December 18th.
If we could go down to the bottom of the document. Mr. Fairlaw. Now, at the bottom and to the right of the document, you see some numbers beginning with 3713.
Yes.
And what are those numbers?
It appears to be an American Express number.
And is there a signature on the credit card receipt?
Yes.
Can you read that signature to us?
Nicole Brown.
Thank you. That's all I have.
Mr. Cochran?
Thank you for coming here. Thank you. Good afternoon, Ms. Flemich.
Hello.
How are you?
Good.
Good afternoon, ladies and gentlemen. Now, as I understand your testimony, Ms. Flemich, what you told us is that if we look at this Bloomingdale's glove purchase receipt there, you can't tell us the color of the gloves purchased. Is that right?
That's right.
You can't tell us the size of the gloves purchased. Is that correct?
Correct.
And as I understand from looking at the receipt, this purchase of 2 pair of gloves was made on December 18th of 1990. Is that correct? That's your understanding?
Yes.
And further, if we are to look at the style number of these gloves, 70268 there. If I can make it, Jonathan, can you usually go down to 70268, please? That style number 70268, you're telling us that that was not a style number that Bloomingdale purchased from Aris Isotoner in 1990. Is that what you're indicating?
I'm indicating that that is not a style number that existed at Bloomingdale's ever.
All right, well, let me ask you this. Is this number 70268, is that a style number that existed with Aris Isotoner in 1990?
Not that I know of.
Have you done any checking in that regard?
I've inquired.
All right, and who did you inquire of?
I called Aris Isotoner to see if that number existed.
And where did you call?
I called the New York office.
And who did you know the name of the person that you spoke with, ma'am?
At the time, Steph Fogelson.
Steph Fogelson?
Yes.
And do you have a report from Steph Fogelson?
No, not really. He was not sure.
You know how to spell Steph Fogelson for our court reporter?
Fogelson.
How do you spell the first name?
Steph, Steph.
Thank you.
And what was the time of that conversation with Steph Fogelson, ma'am?
Was the time when I was shown a receipt at Bloomingdale's and when I started to inquire what the merchandise was. The 70263, my record showed 70263. This was 70268. I had no record of 70268, so I called the resource and asked them if it ever existed.
Let me get back to my question now. What was the date that you called Mr. Fogelson?
Probably sometime in January
Of what year?
of this year.
So January of 1995, you called him, and you found out, did you not, that the style number 70268 did in fact exist with Aris Isotoner gloves, and in fact it had been assigned to a customer named Herring. Isn't that correct?
No.
Sustain,
Well,
Could you repeat the question?
let me rephrase the question.
please.
Thank you. Did you find out in the course of your conversation, first of all, that Aris Isotoner did in fact have a style number of 70268? That was a style number that they produced.
Sustain.
I still don't understand the question.
Well, you don't have to answer right now.
When there's an objection and I sustain the objection, you don't have to answer the question.
Thank you.
All right. The purpose, as I understand your call, was to find out about other style numbers produced by Aris Isotoner. Is that correct?
Yes.
And you had a conversation with Mr. Steph Fogelson in which you inquired as to whether or not there were other style numbers produced by RS Isotoner, specifically whether or not there was a 70268 style number produced. Did you not?
Yeah.
And I said yes or no. Oh,
You can answer that question yes or no.
Yes.
and you asked that question, didn't you?
I asked the question, yes.
Say yes or no. All right. Did you get an answer to that question?
No, I did not.
Did you get anything in writing with regard to that question?
No, I did not.
Prior to your testifying here today, have you ever seen a report from a Mr. Fogelson, who purports to be the general manager of RS Isotoner Gloves and Knits Department?
No.
You've never seen such a report?
No.
Have you ever heard the name Herring before? H-E-R-I-N-G.
No.
Now, with regard to this purchase back on December 18th of 1990, you at that time were a buyer for Bloomingdale's, is that correct?
Yes.
You were not the salesperson in this transaction, is that correct?
No.
And you didn't see who may have purchased this two pair of gloves on that particular evening or that day?
No.
From the number of the employee, you know it was somebody by the name of Phipps who basically weighed on this particular customer? Is that correct?
Yes.
And have you talked to Ms. Phipps?
Yes.
She's in this building
Yes.
today?
Yes.
You talked to her today, I presume?
Yes.
You've also talked to Mr. Rubin today also?
Yes.
Now, with regard to this transaction that we will dart and ask you some questions about, as I understand it, there's nothing on this particular sales slip that tells us this is an RS Isotoner glove, is it?
Yes, the vendor number tells that it's an Eris,
Yes.
and the style number and the price, $55, tells me that it is an Eris leather light glove.
Right, but then when you look at the style number, that is a style number that was not a style number assigned to Bloomingdale's, isn't that correct?
All except the last number.
I'm asking you, is that number, it is not a number that was assigned to Bloomingdale's, was it?
It was not a number that was assigned to Bloomingdale's.
Right. And as Mr. Darden pointed out, that's a mistake, you believe?
Yes, I do.
But you were not present at the time of this purchase, is that correct?
No, I was not.
And what you've been asked to do is to look at some records that are now approximately 4.5 years old, is that correct?
Yes.
And to try and interpret them for us, is that correct?
Yes.
Now, these particular gloves that were shown to you during the break, was that the first time that you'd seen these particular gloves?
No.
When had you seen them before?
In January.
And where did you see them at that time?
I saw them, I believe, at the evidence place.
At the police department?
Yes.
That was you came out here. Do you live in California?
No, I live in New York.
All right. So you came out here from New York and you looked at the gloves at that time?
Yes.
So when we saw these during the recess today, was that the second time that you'd seen them?
Yes.
And who, may I ask, was present at the time you saw them in January?
Phil Van Etter.
Detective Van Allen? Anyone else?
Detective Lang.
Anyone else?
There could have been someone else, but I didn't know the name.
All right. Those are the only ones you can recall at this point?
Yes.
And you didn't make any reports or anything regarding that particular visit, did you?
No.
And I think we've established that you can't tell from this receipt either the color or the size of these particular gloves. Is that correct?
From the receipt?
Yes.
No.
Now, with regard to the gloves, and if we might just see the gloves, Your
Which one do you want, Mr. Chappell?
Let's start.
I think Mr. Cochran might have to change.
Yes, Your Honor, we certainly made everybody more sensitive about gloves around here. I'll be glad to.
Mr. Wooden has put another piece of clean paper on the shelf before the witness.
Thank you, Your Honor. They're both in here.
You may.
For the record, Your Honor, I'm taking People's Exhibit number 9 for identification out, and I'm going to place this before the witness.
Actually, that's LAPD item number 9. That's People's 164A.
Thank you. I didn't recognize this. Now, this is this particular glove that I placed here is one of the items that you saw back in January. Is that correct?
Yes,
And this is one of the items that you saw here in court today. Is that correct?
yes,
And if we're to look inside this particular item, it has some kind of a lining, and is that cashmere lining as far as you know?
yes,
And in this particular glove, which I guess is the right glove, there are no markings in this glove that came from the factory, are there?
no.
There are no markings that came from the factory, is that correct?
No.
All right, the writing inside this glove was placed by someone at a later time, is that correct?
Yes,
This is a brown glove, is that correct?
yes,
And can you tell the size of this glove?
yes,
I'm
it
looking at it.
appears to be an extra large glove.
All right, Matt, try this on you. Supposed to be an extra large glove?
Yes,
Are these gloves, do they come, where are they made?
they're made in the Philippines.
Do they come in are they extra large, is kind of small?
No, but they stretch.
I see, so this is a normal extra large glove, is that correct?
Yes,
But you're saying they stretch?
yes, but that doesn't fit you.
No, it's too small.
It's too big.
It seems to be, since I'm wearing it, it seems too small for me, but we won't argue about that. You're saying, excuse me. And I'd like to get to that document.
Mr. Wooden?
I believe this purports to be the left-handed glove, Your Honor.
That's People 77.
It's 77. And this People 77, if you know, is that to appear to be at least similar to the other glove that you saw back in January of 1995?
Yes,
I presume that you did not put your initials on either of those gloves at that time, is that correct?
my initials?
Yes, you didn't put your initials on either glove, did you?
No,
All right. You were just present with Detectives Van Adder and Lang at the time that these gloves were displayed to you, is that correct there?
yes,
And at the time, when you saw Detectives Van Adder and Lang handle these gloves at that time, were they using any kind of paper like this?
yes,
Were they using any gloves, if you recall?
absolutely.
You recall that, do you?
Yes, because I touched the gloves and I had to use the latex gloves and butcher paper and
this particular glove has a label inside of it, is that correct?
yes,
And the label says Eris, is that correct?
yes,
And it says Cashmere line,
yes,
and it says Made in Philippines,
yes,
and it says extra large, is that correct?
yes.
Is there any other, is there a particular lot or style number in either of these gloves indicating this is a 70263 glove?
No, not that I know of.
What, you want to take a look?
I already looked.
So is it in there?
Not to the visible eye, no.
All right, well, not to the visible eye?
Right,
All right, did you use anything other than the visible eye to try to determine that?
that's what I used.
All right, so that's what you used?
Yes.
And you did not see anything that indicated 70263, did you?
No, I did not.
Did you see anything that indicated 70268?
No,
Did you ever have a conversation with Detective Van Adder in which you discussed the subject of whether or not Detective Van Adder ever spoke with Mr. Steph Fogelson? Well,
I don't know if he had a conversation with Steph Fogelson.
that wasn't the question. Did you ever have a conversation with him wherein you discussed whether or not he'd ever talked to Mr. Fogelson?
No,
And is this supposedly also an extra large glove?
yes, it is.
Now, prior to coming here to testify today, have you had occasion to watch these proceedings on television?
I work, so only the answer is not too much,
Well,
except on the news.
of course, let's get back to my question. Have you watched these proceedings on television?
Sometimes, yes.
And that was during the course of this past year, is that correct?
Yes.
When did you receive your subpoena and were advised that you to testify in this matter?
I didn't receive a subpoena.
You were told that you were going to testify at some point, Harvey?
Yes.
When was that?
Yesterday, Tuesday at 4:30.
Well, you live in New York, right?
Yes.
And you were told Tuesday at 4:30. Were you out here when you were told that?
No.
You're still in New York?
Yes.
And when you came out here in January, did you suspect you might be testifying in this matter?
I wasn't sure.
But you were told that you were a potential witness, is that correct?
Yes.
And you were called yesterday and told to come to testify, is that correct?
Today's Thursday? Tuesday. I was
Tuesday,
called.
rather. Tuesday you were told. And then you came to California yesterday.
Yes.
And did you talk with the district attorney's office or representatives there out before you testified today?
Yes.
Who'd you talk with?
Patty Jo Fairbanks.
And who else?
Chris Darden.
Mr. Darden here?
Yes.
Did you talk with Mr. Darden back in January of this year?
No, I did not.
Now, was your testimony that Bloomingdale's sold 300 pairs of extra large Eris isotoner gloves, brown? Was that back in 1990? Master. Oh. Is that correct?
I was asked how many pairs were purchased in brown,
All right.
and I said approximately 300 were purchased in brown.
Were purchased by customers, is that correct?
No, purchased for Bloomingdale's to sell.
All right, purchased to sell to customers, is that correct?
Correct.
And over what period of time were these 300 pairs purchased by Bloomingdale's?
Between October and December,
Of what year?
90.
All right, so between the period October to December 1990, Bloomingdale's purchased 300 pairs of Eris isotoner brown gloves, is that correct?
Extra large.
All right. Are you aware that the original order by Bloomingdale of Eris light gloves was approximately 6,000 pairs?
The original order for Eris leather lights were 12,000 pair.
All right, well, let's talk about that. It wasn't 6,000 pairs, it was 12,000?
The purchase was approximately 10 to 12,000 pair,
All right, which was it, 10 or 12?
between 10 and 12.
All right, and when was that original order?
For October delivery.
All right, so we could expect then they received somewhere between 10 or 12,000 pairs of these Eris light gloves shortly after the order and for October of 1990. Is that correct?
Yes.
And what you're telling us is that during the period between October and the end of the year, let's strike that. Of that number, 300 were of the extra large brown variety. Is that correct?
Yes.
Do you know how many you sold during that period of the 300 pairs that were brown extra large?
Approximately 200 were sold.
200 of the 300. And how do you know that?
It's about a 65% sell-through, and that is a average normal sell-through for gloves during a fall season.
All right. So are you giving us your estimate, or are there some records you referred to prior to coming to California?
I'm giving you an estimate or an approximation of what I believe sold.
Okay. So let me ask you this, have you had occasion to go and actually check what was sold between October and December of 1990 regarding these gloves?
I don't have documentation that proves that.
Okay, I understand. What you then have given this jury is your best estimate of what would happen in a sale over Christmas time and in the fall. Is that correct?
Yes, on this particular glove.
And this is garnered over your experience. Is that correct?
Yes.
All right. So it could have been more or it could have been less. Is that correct?
Could have been.
All right. But you don't have any records to back that up, do you?
I have records that back up that approximately 65% sell-through on leather gloves or gloves during a fall season is a very good estimate.
Right. I understand that. But you don't have any records to say the exact number, do you, ma'am?
No, I do not.
Okay. So we'll accept the fact that about 65% you believe could have been sold during this period. Is that correct?
Yes.
That's how you arrive at the number of 200?
Yes.
Is that correct? Now, if you know, are there any knockoffs of these gloves that are sold, at least back in 1990, or produced?
Not that I know of because of the distinct characteristics.
So you're not aware of any knockoffs, right?
No, I am not.
And with regard to the two gloves that I put before you, you can't tell by looking at those gloves whether they're actually an actual pair, can you?
They appear to be a pair.
They look similar, don't they?
They sure do.
But there's no way you can tell whether those are the same, those gloves were purchased at the same time.
No.
Can you?
No.
You can't do that, can you?
No.
In your business, have you had occasion to do any investigations regarding so-called knockoffs of these kinds of gloves?
Sure, as a buyer, I think that it's very important to be aware of what's going on in the marketplace. So, yes, I study, I go to competition, I go to stores. I get the opportunity to see every single glove manufacturer. I go into factories, etc. And I have not seen a knockoff of these gloves.
All right. Now, with regard to the barcoding of this particular number, barcoding is a procedure by which you would swipe the glove through some kind of electronic procedure and you would actually get the number up. Is that correct?
Yes.
And as I understand your testimony, in December of 1990, when Ms. Phipps made this particular purchase, you did not have barcoding at Bloomingdale's. Is that right?
Not at that time, no.
So that the style number that Mr. Fairlow would be kind enough to put up there for us was manually entered. Is that correct?
Yes.
And hence we got this number 70268. Is that correct?
Yes.
Have you checked the other numbers that were on that particular receipt
Yes.
for accuracy? You've done that?
Yes.
Do any of your receipts or any of the receipts you had back at that time spell out either the color or the size of a particular item at all?
No, they do not.
With regard to the prices of gloves back in December of 1990, I presume that Bloomingdale's sold a number of different kinds of gloves at that time. Is that correct?
Yes.
And were there other gloves that were of the same price or the same discount accorded during December of 1990 as Eris isotoner?
Not at the same price.
There were no other gloves in which the discount rate would be 30%?
No.
At that time, you sure about that? Do you have records to that effect?
No, but I remember very clearly because I spent a great deal of time on the selling floor selling gloves personally myself. I was very involved on each style and understanding what made it sell, what made it not sell. And I know that there were no other gloves at $55 specifically from Eris.
And that was back in 1990. You remember that and you know that?
Yes, I remember that.
Were there any other gloves other than Eris gloves that sold for that approximate price? $55. Back in December of 1990.
I don't recall.
That's what I'm asking you. I wasn't just talking about Eris. I was talking about any gloves.
Okay.
In Bloomingdale's in December of 1990. Were there others? Or can you not tell us?
I can't recall.
All right. Just a second, Your Honor.
Certainly.
These gloves that were ordered from Eris, were they shipped to Bloomingdale's in October or were they shipped in August, if you know?
They were shipped in the fall season. They were shipped on several different orders. Depending on how the manufacturer shipped, they came into our warehouse approximately October through the beginning of December.
These particular gloves retail for what, $18 or $19?
These gloves retail for $55.
I mean, they wholesale for $18 or $19.
They're about $20.
And they retail for about $55.
$55.
Is that right? It's a nice markup, isn't it? Just curiosity.
No comment.
That's all right.
They were 30% off.
Nice. But that was only at Christmas time, right? All right. Very well. Thank you. I have nothing further on this.
All right, Mr. Darden, any further questions for Ms. Bemich?
Ms. Bemich,
Prince.
an important letter from upstairs, Your Honor. Ms. Bemich, what was it about those gloves that made them sell?
That goes to speculation.
And I think she's an expert.
These gloves were extremely lightweight. The reason they sold, from my experience in waiting on customers, is that they were almost like a second skin. You could pick up a penny or a needle practically with them, and they were very, again, they're very, very thin. And many people like that about these gloves. And that's why they were called leather lights, and that's why we marketed them leather lights, and it was a big seller. It was a big part of my business.
And you told us that approximately 200 pairs of those gloves in size extra large and in a brown color sold during Christmas season, 1990?
Yes, approximately 200 pair.
Okay. I neglected to ask you when the receipt was on the screen where that particular purchase was made.
In the 59th Street store.
In New York City?
Yes.
Okay. Are you aware the defendant has a home in New York City?
Sustained. Sustained.
Okay. And you don't know how.
Again, sustained.
And you don't know how those gloves made it here to Los Angeles, do you?
No.
Okay. Or to Bundy.
No.
Overruled.
You don't know how one of those gloves found their way to Bundy.
No.
Overruled.
Do Eris isotoner gloves usually have a style number imprinted somewhere on the glove?
Not that I know of.
But you mentioned a moment ago that there was no style number that you could see with the naked eye.
No, there is no style number that you can see.
Are you suggesting that there is some type of number, identification number somewhere on the glove?
I believe there's some kind of identification on the glove underneath the lining that may tell you the lot number or whatever, in what sequence they were made. I'm not an expert in this area.
And when you identified the two gloves shown to you by Mr. Cochran and myself, was that identification based on the sales receipt or was it based on your observations of the gloves?
The observation of the gloves.
You know that style when you see it.
I know that style.
Now, is there a particular way that gloves are supposed to fit on a man's hands?
I say fit like a,
Oval. Oval. Oval.
How are they supposed to fit, Ms. Femich?
supposed to fit like a glove. They're supposed to fit tight. They're supposed to fit tight and snug, and they stretch, and they're not supposed to be baggy.
As they were on Mr. Cochran's hand.
That's right.
Okay.
Sustain. Sustain.
Do the gloves appear baggy on Mr. Cochran? If we could just put the sales receipt back up for just one moment. It's 372A. Ms. Vimich, assuming that there was no style number, that is no 70268 or 70263 on the sales receipt, could you still tell us the make, style, model, and price of the gloves sold on December 18, 1990?
Yes, because it says that it is a leather glove. It is said it's made by vendor Eris. It was $55. Two were purchased at $55, $110, and 30% off is $77. And I only had one glove from Eris at $55.
Okay, and so $77 is 30% of $110?
Yes.
I think it's 70%.
70%.
We never give markdowns.
Certainly.
And if we could go down to the bottom of the receipt again. Okay, you see the name Nicole Brown written there on the receipt?
Yes.
Okay. Are customers required to sign their names when they receive the merchandise and upon the purchase?
Yes.
Okay. And is that apparently what Nicole Brown did in this situation?
Yes.
Thank you.
Mr. Cochran, anything further?
Just a couple of questions. Regarding these gloves, Ms. Femich, these gloves are sold only for men, is that correct?
Yes.
These are not unisex gloves, are they?
No.
Would you agree if the person who was wearing a pair of gloves could best determine whether or not those gloves were fitting appropriately? Is that kind of a personal thing?
Sure.
Because as a buyer, the customer's always right, isn't he?
Sure.
So if the customer told you those gloves were too small for him, you'd accept that, wouldn't you?
If you wanted to buy them, I would not.
You wouldn't
Tell
quarrel,
you
would
no.
you? All right.
I'd give my opinion.
All right, well, thank you. Now, with regard to the actual numbers of gloves sold, I believe you told us that your general estimate would be that approximately 200 of the 300 pairs were sold during this particular fall period, right?
I said 300 were purchased approximately in
Yes.
brown extra large, and about 200 were sold.
Yes, that's what I said. 200 were sold, right? And would the other 100 then be sold at a later time, or what would happen?
They would be returned to the vendor.
All right. And you have no records as to what number was actually returned to the vendor?
No.
Okay. And with regard to the receipt that Mr. Darden just placed up there again, with regard to how you're able to identify any of the information, boils down to the correct inputting by Ms. Phipps as to those various numbers. Isn't that correct?
Yes.
Right. So if she's wrong about some other number about the vendor, and she was wrong about the style number, that would affect what you're telling us. Isn't that correct, ma'am?
It wasn't only the style number that made me believe that this was an Eris leather light. It was all the other combinations. It was the class number and it was the retail number.
Okay, let me get back to my question. My question was if she was wrong about other numbers entered there manually, as she
Yeah.
was with the style number, that would affect the information that you're giving us here today. Isn't that correct, ma'am?
Yes, it could have.
That's right. And that's one of the reasons why Bloomingdale's and other modern stores have now gone to the barcoding effect. So you take out the aspect of human error. Is that correct?
Sure.
All right. Thank you very kindly.
Mr. Darden, anything further?
So that the record is clear, 200 pairs of extra large brown Eris isotoner
We're sold.
sold during that Christmas season. And when men buy gloves, do they tend to exaggerate the size of their hands when they?
I'm just informing that.
Oh.
Do they tend to exaggerate the size of their hands when they purchase gloves?
Oh, she's an expert in glove sales.
Usually women buy gloves for men.
Do they exaggerate the size of the man's hands when they buy them?
Is that a serious question, Mr. Darden?
Yeah.
All right. Do you have many returns from customers with gloves? For resizing?
A few, not an inordinate amount, a few.
Gloves you showed you today, they're definitely exclusive to Bloomingdale's, yes.
They're exclusive to Bloomingdale's, yes.
All right, Ms. Vimich, thank you very much. You're excused. All right, Madam Court Reporter, would this be a good time to switch reporters? All right, we'll take a 10-minute recess to switch court reporters, and remember my admonitions to you. All right, we'll take a 10-minute recess to switch court reporters.
Size, 2 being a 3-digit number, which indicated the individual who actually cut the gloves, and then another 2-digit number indicating the sequence in which they were made from the leather that was given to the cutter at a given point in time. But I don't know if those numbers exist in there right now.
All right, you haven't seen those numbers with regards to the gloves before you, have you?
No.
And at no place has there ever been a lot number or style number like 70263 therein. Is that correct? That was not part of the procedure, was it?
No, it was not part of the procedure.
Now, as I understand it, there are Eris isotoner gloves all over the United States. Is that correct?
That's correct.
And all over the world, for that matter. Is that correct?
That's correct.
Are they Bloomingdale's is a store exclusive to the United States? Are they?
I believe their retail operations are. They may have some mail order internationally. I'm not 100% sure.
So back from the 10-year period, 82 to 92, would it have been possible through Bloomingdale's mail order catalog to order these particular gloves during that time frame?
At some points in time, this particular product was in various Bloomingdale's catalogs.
So you could be in France and order those, is that correct?
If you were on the mailing list, it's a possibility.
Now, do you have any kind of a breakdown of the difference in colors? Let's assume that in 1990 you ordered 10,000 pairs of these Aris light gloves. Do you know how many different colors did you have at that time?
At that time, I believe we had 4 colors: black, brown, gray, and a medium brown.
And do you know the breakdown of the 10,000, how they were ordered?
60% plus would be black, approximately 30% or 28% would be brown, and then the other colors would really be just 10% or so.
There would be much less, is that correct?
Yes.
And would that remain fairly consistent over the 10-year period that you were involved with the company, and at the time these gloves were the same style?
No. Actually, the mix of black to brown gravitated dramatically more toward black as we went farther into the 80s.
More toward black and away from brown?
Yes.
Earlier it had been brown more than black?
No, it was never more, but at one time it was 50-50.
All right, and that was based upon the sales trends, is that correct?
Consumer demand.
Yeah, sales trends, the way
Yes.
people purchased them, is that right?
Yes.
All right. Now, with regard to the gloves that you were shown by Mr. Darden a short time ago, in looking at those gloves, they appear similar to you, did they not?
Yes, they do.
But you can't say they're the exact same gloves were sold at the same time, can you?
What I was looking at when we looked at the gloves earlier was the grain of the leather. The way these gloves were manufactured, just looking at them in this condition, they appear to be a pair that was cut out of approximately half of a skin. And that's what I was looking at. They appear to be a pair.
But in looking at them, you can't tell us for sure they're from the same particular lot, can you? You can't say they're the same, can you?
It's difficult.
All right. There's no individual characteristics that would allow you to make that particular goal. You can say they look similar, right?
They do look similar.
All right, and
That's all I can say.
All right, I appreciate that. And to you, they appear in your color scheme what color is that glove? And do you have the left glove or the right glove?
This is the right.
The right glove. What color is that right glove?
This is brown.
And there's no way to look at that particular glove before you now, and you can't tell us, I presume, whether that particular glove was purchased in 1982, 83, 84, all the way up to 92, can you?
I cannot determine the exact date of purchase.
All right. So in other words, what you can tell us is that that particular glove that you believe is the style that was exclusive to Bloomingdale's was or could have been purchased at any time between the time frame 1982 to 1992 when they changed the stitching, right?
Correct.
Is that a fair statement?
Yes, it is.
May I have just a second, Your Honor?
Certainly.
Starting in 1982, were these gloves made starting then in the Aris Philippines factory?
Yes, they were.
And would that be correct then in assuming that for the 10-year period we've been talking about, from 82 till about 92, that all the gloves, whatever numbers, from 1,200 pairs to 10,000 pairs, would have all been made in that factory in the Philippines?
I would only commit up until 1990 for myself.
Because you left.
Yes.
But no reason to believe they went to some other factory after you left.
I'm not aware of any other factory that could make this product, but I wasn't there, so I can only commit up to 1990.
But you can commit from 82 till 1990, the time you left, that all those gloves were made at the Aris Philippine factory. Is that correct?
That's correct.
And the other styles that made, there were other styles made for other parts of the world, as I understand. Is that correct?
That's correct.
Did you ever talk to a customer by the name of Herring, H-E-R-I-N-G? Did you ever talk to him personally?
Not personally.
Was that the customer whose style number was 70268?
That's what documentation that I've seen indicates.
And that's the customer whose buyer
you spoke with, is that correct?
It was really the sales agent in England that the style was developed for a sales agent, and then the sales agent, I believe, showed it to the customer and eventually ended up getting an order for that particular style number.
And the customer's name is here.
Yes.
Thank you.
Mr. Darden?
A little bit, Your Honor. So the documentation you've seen, sir, indicates that 70268 was never sold in the United States?
That's correct.
Mr. Cochran asked you some questions about the percentage of gloves sold that would be black in color and those that would be brown in color, as well as other colors. But in 1990, assuming you had 10,000 pairs of these gloves, what percentage of those gloves would be brown?
30%.
Okay. And what percentage of that 30% would be size extra large?
8%. No, I'm sorry, 8% of the total, not 8% of the 30.
Okay. 8% of the total number of gloves would be extra large?
Right.
But what percentage of the total would be extra large in size and brown in color?
I'm not sure if I understand the question.
Okay. Well, if you had 10,000 pairs of Aris isotoner leather light gloves.
On a 10,000 unit basis, there would be approximately 300 units in extra large brown, totally available.
And of those 300 units, you would expect to receive back into your factory approximately 100 pairs?
It could be that high.
So in your view, then, Mr. Rubin, approximately 200 pairs of brown extra large Aris isotoner leather lights would have been sold during 1990?
Rephrase the question.
In your opinion, how many size extra large, brown in color, Aris isotoner leather light gloves would have been sold by Bloomingdale's during 1990?
Between 200 and 240 pair.
And did I hear you correctly? Did you testify that the lot sold to Bloomingdale's during 1990 was the largest lot?
Largest lot of this particular style?
Yes. Yes.
Within the mix of what Bloomingdale's purchased, this was the largest lot.
Okay. Okay, well, how many did you sell to Bloomingdale's during 1990?
Of this particular style?
Yes.
When I left, what was on order to be shipped was approximately 12,000 pair. However, these orders were set up to be delivered on an ongoing basis, starting at the end of July, going through the middle of November. Based upon the actual performance of business during the October-November timeframe, I am not 100% sure that they took in all of the pairs that they committed to.
Okay. At any event, the maximum number of brown extra larges that would have been sold during 1990 is 200 to 240, correct?
That's correct.
And in 1982, the first year that these gloves were manufactured apparently and sold to Bloomingdale's, correct?
That's correct.
What would the maximum number of brown extra large, let's strike that. How many pairs of brown extra large Aris leather lights would have been sold in 1992?
There may have been 50 pair in brown, extra large.
How about 93?
Twice as much.
I'm sorry, 83. Twice as much?
Yes.
Okay. About 100?
Yeah.
Okay. How many size extra large, brown in color, Aris leather-like gloves would you say were sold through Bloomingdale's from 1982?
In 1982?
From 1982 through 1990.
I really would be speculating at this point. I'd have to actually start to calculate what the progression was and then factor in the consumer demand shifting from 50% black and brown and then shifting more toward black. If I had a guess in total,
Okay. Okay.
Ask another question.
Okay. But as the years went on, the color brown in size extra large became more rare. Is that correct?
yes.
Okay. Have you seen the sales receipt from Bloomingdale's for a pair of Aris gloves?
Yes.
And I've just been handed another exhibit. Can I confer with Mr. Cochran from?
With the court reporter, please. Need to conduct some questioning out of your presence. I'm going to ask you to just step back into the jury room. This will probably only take about 10 minutes. Reflect all the jurors have withdrawn from the courtroom. Mr. Rubin is still on the witness stand. Mr. Darden, proceed.
I have here in my hand what appears to be a pair of leather gloves. There is a tag attached. The tag reads Eris Leathers by Isotoner, extra large, cashmere lined. Selling price of $55 by Bloomingdale's. And they be marked 372C.
372C.
Mark. 372C. Are those Eris Isotoner gloves?
They're Aris gloves, but these are not Aris Lights gloves that were like the ones we're talking about from 1982 until 1990.
When were those gloves manufactured, if you know?
These gloves?
Yes.
Only because of what I've learned recently, I was given the impression that starting in 1992, they changed the actual sewing configuration to a different type of construction, but still used the same connotation that it was an Aris Lights glove.
Are those gloves cashmere lined?
Yes, they are.
Looking at those gloves and the two gloves that you've seen here in court today, can you tell us whether or not they're the same size?
Same size?
Yes.
They're tagged the same size.
Okay. They appear to be the same size.
They appear to be the same size. They were supposed to be the same size.
Okay.
If I had to speculate, though, actually, I wouldn't speculate. I could tell you that this particular pair would actually fit tighter than this pair because of the sewing construction.
Are they both made of leather? That is the pair in your hand as well as the glove on the bench there?
They're made from leather, but they're not the same leather by any means.
Okay. Moment, Your Honor. Can you tell us whether or not those new gloves will strike that? Have you noticed Mr. Simpson's hands at all?
I actually haven't.
You can't tell us whether or not either of these three gloves will fit his hand?
I would venture to say that almost every glove that was manufactured by Aris Philippines from size medium through extra large would get on his hand. Some might be tight, some might be loose, but they would get on his hand.
Thank you, that's all.
I think I have to ask a question this here. Thank you.
You're welcome.
I object.
Mr. Darden? All right. Why don't you collect the new exemplars from Mr. Rubin, please? Mr. Darden, you want to collect the exemplar from 374C, 372C? I take it you're not going to use that in front of the jury?
Well, Your Honor,
Probably not.
probably not.
All right, let's have the jurors, please.
Before the jury returns, however, we'd like to have Mr. Simpson try on the original evidence items.
Mr. Cochran, any comment?
The only problem is that I would want you to have gloves on under it. You try to get them without the rubber gloves used, make it look used. And I'd like the rubber glove approach that way. Sure, I like that.
Sure. All right, don't go away, Mr. Rubin. All right, let's have the jurors, please, and may I see Deputy Magnera first, please? Ladies and gentlemen, record show reflect we've been rejoined by all the members of our jury panel. Mr. Darden, do you have any further questions, Mr. Rubin?
Just a few, Your Honor. Mr. Rubin, you said that 8% of the gloves sold of the extra large brown in color Aris leather lights would be
8% of the actual brown. Out of the 12 pair per pre-pack, one pair would be extra large.
okay. So how many in 1990 then brown extra larges were sold?
300 totally available, possibly sold 200 to 240, depending upon conditions.
Okay. Your Honor, at this time, the people would ask that Mr. Simpson step forward and try on the glove recovered at Bundy as well as the glove recovered at Rockingham.
All right, do you want to do that? All right, you can do that seated there. All right. And I think so the jury can see, I'll ask Mr. Simpson to stand. All right. Mr. Darden, which glove do you have?
This is the fighting glove, Your Honor.
All right.
And after Mr. Simpson tries on the gloves, I would ask that he be required to step back over to the jury and again show him his bare hands.
Well, we'll get to that in a second. All right, the record should reflect that, as is our practice with these gloves, Mr. Simpson will have a pair of latex gloves on while doing this.
I'm handing Mr. Simpson the left glove right hand.
That's People 77.
Walk up close, John.
All right.
As soon as Mr. Simpson seems to be having a problem placing the glove on his hand, should he be
Sustained.
also again, Mr. Simpson? The other glove.
This is People's 164A. Is that the right-hand glove?
Yes, sir.
All right. All right, Deputy Jex, would you just take a step back, please? Thank you. All right, records reflect that Mr. Simpson has both gloves.
And in front of the jury,
Yes.
and Mr. Simpson's indicating that his fingers are all the way into the glove, Your Honor.
All right. Thank you, counsel.
Mr. Simpson told the jury that the glove is small.
All right.
Your Honor, before Mr. Simpson goes back, could we ask him to replace the left glove onto his hand?
All right.
Could we ask him to straighten his fingers and extend them into the glove as one normally might put a glove on?
I object to this statement by counsel.
All right. He appears to have pulled the gloves on, counsel. All right. Would you show that to the jury, Mr. Simpson, in that manner? Thank you. Other hand, please.
Could we ask him to make a fist with his left hand while the glove is on, Your Honor? Could we ask him to make a fist with his right hand while the glove is on?
He is doing both.
Could we ask him to grasp an object in his hand? Marker, perhaps.
All right. Mr. Simpson?
We ask him to grasp the marker in his hand like this.
I object to this, Your Honor.
Yes,
I object.
I agree.
Counsel,
So
go
we
ahead.
ask him to completely grasp the marker in his hand,
Yes.
whether it's raised or not.
Yes. All right. Thank you, counsel.
Thank you.
No longer an issue of cross-contamination, Your Honor. I have nothing further.
All right. Mr. Cochran?
I'm sorry, can we approach one moment before we, go on? Approach one moment.
Yes, with the court reporter. Mr. Darden, would you wrap it up, please?
Your Honor, if
All right, records reflect that Mr. Rubin has examined both Mr. Simpson's left and right hands. Mr. Darden.
Mr. Rubin, you sold thousands and thousands of leather gloves throughout the world, correct?
That's correct.
What size glove would you say would fit Mr. Simpson's hand?
Over. You can answer.
In some styles, size large, in most styles, extra large.
Should the gloves shown to you here in court today have fit Mr. Simpson's hand, in your opinion?
Speculation.
Over. You can answer the question.
At one point in time, those gloves would be actually, I think, large on Mr. Simpson's hand.
So you expected then that these gloves would have fit his hand here today, is that correct?
Just an objective from that speculation.
Sustain.
Well, the question is this: would Mr. Simpson's hand fit into these gloves as they are today, in your opinion?
Form that question. I think off the speculation.
Sustain. Sustain.
Should they be able to fit into these gloves?
Objective form, that's what should be. Objective answer.
Over.
His hand should be able to fit into that pair of gloves.
Okay. Now, would you expect that the fact that he's wearing latex gloves here today would that inhibit his ability to extend his hand through the gloves?
I personally have never put on latex gloves and tried on gloves, so I really couldn't say, but I would say that appears to be a factor. Because when he showed,
That's fine. That's good.
Okay. Can you give the jury any explanation as to why Mr. Simpson couldn't fit his hand into the glove here today?
Sustain.
The manner in which Mr. Simpson put the gloves on today?
yes, I did.
Okay. You've seen people put gloves on in the past.
Yes, I have.
Did he put the gloves on in a manner consistent with what you've seen other people?
That's relevant material, Your Honor.
Sustained. The jury observed what happened.
Anything unusual about the way Mr. Simpson put the gloves on based on your experience?
Object, Your Honor.
Sustained.
Could you tell whether or not he was intentionally holding his thumb in a certain position so he couldn't put the gloves on?
Object that.
Sustained. Sustained. Counsel, the
I have
jury
nothing further,
observed.
Your Honor. I have nothing further.
All right. Mr. Carter? Anything else?
Yeah, just a second there.
Certainly.
I'm mindful of the hour. I think we can finish. Mr. Rubin, did Eris Glove Lights make a size of glove called double XL?
Not prior to 1990.
And since 1990, have they made a double XL?
I understand they have.
And that's a extra, extra large, is that correct?
That's correct.
Now, with regard to the sizes of gloves, these gloves that were made back between the period 82 to 92 that we talked about, were they made so that each extra large was the same size as the next extra large? Or is there some variation in the sizes?
The intent was for them to be exactly the same. The patterns that were utilized were exactly the same size, but each few square feet of leather does have its own characteristics as far as stretchability.
So that one extra large might actually be smaller than another extra large. Is that a fair statement?
That's correct.
And there is that variability in the lots as they turned out. Is that right?
That is correct.
And you would expect that an extra, extra large would be larger than an extra large. Is that correct?
That's correct.
Thank you very kindly, sir.
Guard? All right, Mr. Rubin, thank you very much, sir. You were excused. All right, ladies and gentlemen, we're going to take our recess for the evening. Please remember all my admonitions to you. Don't discuss this case amongst yourselves. Don't form any opinions about the case. Do not allow anybody to communicate with you. Do not conduct any deliberations until the matter has been submitted to you. As far as the jury is concerned, we'll stand in recess until 9 a.m. tomorrow morning. All right?